Yes.
May I please, Lordship? Lordship, this matter we have filed on the last week, Lordship. This matter was listed on second, Lordship, for the motion stage, Lordship. But however, Lordship, all the leftover matter has been fixed today, Lordship, for the motion, Lordship. This matter has been left out inadvertently, Lordship. So this matter, maybe can you take it up with along with the other motion matters?
No, it will come on Monday.
Lordship, the problem is, Lordship, this matter has been fixed in the lower court tomorrow, Lordship, and there is I have to pray for some interim order, Lordship. That settlement has been already arrived between the parties, Lordship, despite the settlement, since the sections is not compatible, Lordship. That's why we are
taken up tomorrow. You will taken up tomorrow.
After the motion, Lordship, today.
It will be taken up tomorrow.
Lordship. Maybe.
Please, Your Lordship. My Lord, I beg to mention item 18.
Yes.
My Lord, in this matter, I need some instructions on the affidavit filed by the respondents. Can this matter be listed on 12, Lordship, next week?
Heard Mr. M. Duncan, the learned counsel, appearing for the petitioner. He submits that she requires some instruction to file an affidavit in reply.
Yes.
Affidavit in reply in the instant matter. Praise for some time. Let the matter be fixed on 12.
Lord, I am appearing for respondent number 5 and 6.
Mr. So-and-so appears for respondent number 5.
Yes.
My Lordship, I beg to mention one criminal petition which was listed on two of this money, Your Honor, for motion, but matter could not be taken up. So kindly matter may be listed tomorrow. Highly hope.
May it please, Your Lordship, item number 8, I beg to mention item number 19 and 20, Lordship.
19 and
20 for
20.
adjournment, Lordship.
okay.
Learned senior counsel is out of station, Lordship.
Okay. Mr. So-and-so submits the learned senior counsel, Mr. M. Patil is out of station. Therefore, praised for some accommodation. Let the matter fixed on
1 week, Lordship. Maybe fixed on for 1 week, after 1 week.
after a week. So let the matter be fixed on 23rd.
Deeply obliged.
23rd.
May Your Lordship. Your Lordship, I beg to mention item number 16, Your Lordship.
Item number
16.
16.
Yes, Your Lordship. I have an instruction from my client that to withdraw this matter, Your Lordship, because they have not
You are appearing for whom?
from petitioner.
Petitioner.
Yes.
Okay. The learned, you are
I'm sorry, Your Lordship.
MS M. Soya, the learned counsel, appearing for the petitioner, submits his instruction to withdraw the matter. The matter is dismissed as withdrawn.
May Lordship. Lordship, I beg to mention for for listing for hearing on 9/3/2026 next Monday.
Why so urgent for hearing matter?
Because Lordship, last previous that left of the matter this court.
When do you want?
9th Monday.
Not possible. Monday is not a hearing day anymore. Oh, this is a single bench matter. Okay.
It's possible.
Okay, we'll fix it on 12th.
Lordship.
12.
Lordship.
Let the matter fixed on 12th. 12.
My Lord, I'm extremely sorry, my Lord. I have some engagement on 12, my Lord. Item number 18. Can it be on 17 instead, Lordship?
17.
Yes.
17 is a division bench matter. Division bench list.
Lordship, it's not for hearing.
Single bench will not be single. Will not be there.
18 then?
The 18th.
18 or 19?
18th, you said some problem.
12 miles is having problem.
12.
Oh, 18 then.
18 miles.
Item is 18.
18.
So 18 to 18 miles, okay.
Obliged.
Item number 1.
My Lordship.
Lordship, this is contempt petition, Lordship, non-compliance of order order dated 18/12/2025 passed by this honorable court in WPC 594 of 2025, Lordship. Lordship, order copy is annexure 1, Lordship. Page, Lordship, page 13, Lordship.
Page 13.
1-3. Yes, Lordship.
What was the direction to be disposed
Directions
of
to dispose of the representations with speaking order, Lordship.
within two months?
Yes, Lordship, within 2 months, Lordship.
2 months is over.
Yes, Lordship.
When?
Lordship, this, we submitted, the certified copies on body of, annexure 1, Lordship. Annexure 1, phase 13, Lordship. Order copy is submitted to the respondent, Lordship. On
When did you submit?
22/12/2025, Lordship.
So 2 months is over.
Yes, Lordship, it's over, Lordship. And this is the, Lordship, notice may be issued.
Okay, heard Mr. Sorenso, the learned counsel appearing for the petitioner. This is an application under section 12 of Contempt of Courts Act 1971, read with Article 215 of the Constitution of India and Rule 9 of the Contempt of Courts in bracket Guwahati High Court, Rules 1977, for willfully and deliberately disobeying and not complied with the order dated 18/12/2025 passed by this honorable court in WPC number 594 in bracket AP stroke 2025 in bracket Nabam Rikam and 5 others versus State of PP and others. Let the notice be issued by speed post as well as in usual course within a period of 7 days of passing of this order. Notice returnable will be within in 4 weeks later. Notice returnable in 4 weeks.
My turn.
Steps you take within 7 days.
Okay, Lordship. My turn.
Matter number 2.
Lordship, here the petitioner is a prominent social activist and a president of Social Action for Youth Association. Now here, Lordship, the petitioner challenges the committal order of executive magistrate who has committed him to the civil prison for a debt he has never denied, Lordship. Now here, in spite of demonstrating bona fide intent by attending proceedings, submitting representation and voluntarily handing over a blank check as security, he has been labeled as the absconder and he has been committed in the civil prison, Lordship. Now that the execution upon which he has been committed to the civil prison,
But did you appear before the village court?
Lordship, I have submitted several
But you
representations.
didn't appear. You did not appear before the village court.
Lordship, I have submitted several representations on
Sir,
my
you
inability
should
to
have been-
attend.
When you received the notice, you have received the Pavana, then but in spite of that, you didn't appear before the village court.
Lordship, that is a aspect that has to be seen, but then another aspect that has to be seen here is,
No, your conduct is not good.
Lordship, I have
Yeah,
submitted,
You have not appeared before this village court.
Lordship will kindly appreciate, Lordship, starting from page 28, Lordship,
Please,
28, Lordship.
28, yes.
I have written several representations, Lordship, before the head Gambura who was conducting that mail at that point of time, Lordship.
But you
18, this is
keep
the
on- but
18,
You keep on writing, but you don't appear.
Lordship, in fact, there were certain difficulties on which account I could not appear, Lordship. And moreover, Lordship, I am challenging this, the decision of the customary court of Model Village, Lordship, which is against me, in fact, which is a expert decision, Lordship, on jurisdictional ground.
It became ex parte only because you didn't appear.
Lordship,
That if you do not appear, then ex parte order is passed, then you come and say that like, you challenge that order. Both the ways you cannot have it. You can have it in one way only. Either
Lordship-
you appear or ex parte order will be passed. What is wrong in passing the ex parte order?
Lordship, in throughout the proceedings, Lordship, I have never denied regarding the debt. I was liable
So
to
that's
pay. to the-
why it should have been there before the court, village court. And you should have submitted your whatever you need to submit, but you did not, you didn't bother about that.
Lordship,
You thought that nothing will happen to you. But this cannot go on like that.
Lordship may kindly appreciate that,
Now,
Lordship.
what is wrong in like putting you in the civil prison? There is nothing wrong.
Lordship, there are certain thing that has to be looked into
What
by
certain
the.
thing? You tell me, tell this court. What are the certain things?
Now, Lordship, my ground for releasing him from the civil prison, Lordship. Number one ground that I'm taking is, Lordship, there is a jurisdictional nullity in underlying the order of the village authority, Lordship.
How?
There is a territorial bar, Lordship.
How?
Lordship may kindly,
That issue you could have raised before the court?
Lordship,
trial
but
court?
verbally we have raised, Lordship. In fact, we have submitted the presentation also, Lordship,
No.
saying that
I
I'm
mean,
not running away from my debt, Lordship. I'm ready to pay, but I was seeking some time to repay that amount, Lordship.
But you have been given opportunities.
Lordship, of course, that is their Lordship, but since I was facing certain financial difficulties, Lordship, so why I could not.
That you could have stated before the trial court.
Lordship, I have stated, Lordship,
appearing
in the
as-
form of representations before the.
Representations will not do when you have received that notice or notice asking you to be there before the court. And it's a customary court, it's a legally constituted court. It's not a simple, some village meeting where you have been called, but you have failed to appear there.
Lordship, here, Lordship, one thing that has to be looked into is, Lordship, that ex parte decision, Lordship, that also has been passed without jurisdiction, Lordship. That is one of
How
my,
you show me?
Lordship, that is one of my challenge in this represent petition, Lordship.
You show me how it is, it doesn't have jurisdiction.
Lordship, may kindly take up AFR, Lordship,
Hmm?
Assam Frontier Regulation 1945.
Yes, give it to me. Mhm. Yes,
Now, section 5 talks about the appointment of the village authorities, Lordship, section 5,
one second.
regulation 5.
Yes,
The deputy commissioner shall appoint such person as he is considered to be the member of the village authority for such village or villages as he may specify and may modify or cancel any such order of appointment and may dismiss any persons so appointed, Lordship. Now, as per the sections, they are appointed, Lordship. Lordship may kindly come to regulation 40, whereby the power of the authorities are drawn, Lordship, under this particular regulation, Lordship.
40.
40, Lordship, 40.
Yes,
Now it says, Lordship, the village authorities shall try all suits without limit of value in which both the parties are indigenous to the Union Territory of Arunachal Pradesh. And this is important, Lordship. And live within their jurisdiction.
where is that? I mean, Arunachal Pradesh then?
Arunachal Pradesh and live within their
One second,
jurisdiction.
one second. There was some amendment whereby that was deleted. Deleted in 2021. The portion you are trying to read. This 40 ends with in which both the parties are indigenous to the state of Arunachal Pradesh. Then deleted and amended by Arunachal Pradesh Civil Codes Act 2021. This has been already deleted. 40 has been already deleted.
Lordship, here my point of contention was,
No, no,
Lordship.
no, you tell me first, clarify this. This has been deleted. এখন করেছে অরুণাচল প্রদেশ এখন সিভিল কোড সেকশন এখন 21 this rule 40 that you were reading,
Lordship. That has been,
it seems to have been deleted,
Lordship, correct, Lordship. That has been deleted, Lordship.
deleted. So after coming into force of Arunachal Pradesh Civil Codes Act 2021, that part is no longer there.
Now, even if they have the jurisdiction, Lordship, now here, when the execution part was done, Lordship, now that we are contending that there is a violation of order 21 rule 40 and 39.
CPC order. Violation
21.
of
Order 30.
execution is pending before which court?
As per this amendment, Lordship, now
Civil
after the
court.
mail order is passed, Lordship, execution is normally done by the executive magistrate, Lord, by the ADC or the DC, Lord.
So the impugn order was passed by the ADC.
Impugn order was passed by the executive magistrate, Lord.
ADC, which is the impugn order?
ESC, Lordship. Lordship will find it page 60, Lord.
This
60, Lord.
60.
He is the assistant commissioner, Lordship.
So he has the power.
He has the power
He
under
has the power. under.
Lordship. He
So
has the
now
power.
you are saying that while passing this order, page which page 60.
60, Lord.
60. Okay, this is before the assistant commissioner Naharlagun. So he has passed this order.
Correct.
Now you are saying that while passing this order, there was some violation
Procedural,
or procedural lapses. Which are the procedural lapses?
Lordship, I'm contending that 51, no? Order 31 or order 21 rule 30.
Read this order. In pursuance to the order.
No judgment debtor shall be arrested in execution of,
First read this execution, so that order, the impugn order.
correct. In pursuance of order number so and so dated Nahavlagan, the 27th October 2025, pertaining to execution case between Toko Bapu, decree holder, and Lika Rajnik, judgment debtor, the IO of the Nirjuli stations produced the judgment debtor before this court. Sri Gyamar Jeevan, learned advocate appearing for the judgment debtor, submitted that while carrying out the execution proceedings, this court and degree holder failed to comply with the provisions of order 21, rule 31, sub rule 1 of the Code of Criminal Civil Procedure prior to arrest of the judgment debtor. Accordingly, he prayed for release of the judgment debtor on the ground of non-compliance with the appropriate provisions. Sri Third Tarum, learned advocate for the degree holder, submitted that all stages of the execution proceedings have been carried out in accordance with the prescribed rules, and then the questions of non-compliance with order so and so does not arise as the execution process is ongoing. He further prayed that the subsistence allowance be fixed by this court today. In view of the above submissions, and since all remedies have been exhausted, the judgment debtor Sri Lika Rajnik is hereby committed to civil prison for a period of 2 months. Degree holder Sri Toko Bapu is directed to deposit the subsistence allowance at the rate of rupees 2,000 per day for 60 days, amounting to so and so.
So where is the violation?
Lordship, before committing him, this subsistence allowance was paid on the same day when he was committed to the civil prison, Lordship.
Yes,
But
when
the
you are-
procedure law says that this subsistence allowance has to be paid before he is arrested and he is committed to the
When was he
civil prison.
arrested?
15.
Hmm?
15, previous day, Lordship.
15.
Yes, Lordship.
And we are committed on 16.
He was committed on 16.
So
On the
where is
same day, he was kept around for 21 hours
But there
without
has to, but there has to
sustenance
be,
allowance.
but there has to be order, has to be an order of subsistence allowance. Without any order of what is to be the amount to be paid for subsistence allowance, how it can be deposited?
Process so why, Lordship, before he has to be, that subsistence allowance has to be paid first, then he can be arrested,
No,
Lord.
he can be understood, but you are saying that like it should be paid. But what amount will be paid? How much will be paid? Who will decide that?
So why, Lordship, that has to be decided first, then he has to be arrested and put behind a bar, Lordship. Now there are,
Now you show me what is the violation of order 21 rule 39?
I'm reading order
Order-
39, Lordship,
Order 29
rule 39,
39.
Lordship,
Subsistence.
sub rule 1, Lordship.
Hmm,
No judgment debtor shall be arrested
hmm.
in execution of a degree unless and until the degree holder pays into the court such sums as the judge thinks sufficient for the subsistence of the judgment debtor from the time of his arrest until he has been brought before the court, Lordship. Now the law provision is very clear, Lordship. Before he is arrested, the subsistence allowance has to be paid, Lordship. Now from this very order, Lordship, apparently it is clear that after his arrest, the subsistence allowance was directed to be paid, Lordship. Fifty-one is 50.
What does it mean by the last two lines? Sums as the judge thinks sufficient for subsistence of the judgment debtor from the time of his arrest until he can be brought before the court.
Lordship, the line is very clear, Lordship. No judgment debtor shall be arrested
What about the
in execution of a degree unless and until the degree holder
pays?
pays into the court such sums as the judge thinks sufficient for the subsistence of the judgment debtor
From the
from the
his
time
arrest
of his arrest
until he can be brought before the court.
until he can be brought before the court.
So what does it mean by that?
Lordship, before he is brought before the court, that subsistence allowance has to be paid, Lordship.
But that amount has to be fixed by the judge.
Lordship, so why before committing him or before the judgment debtor is being arrested, Lordship, the judge has to conduct an inquiry, Lordship. After that inquiry, if found that he has to be committed to the civil imprisonment, then that order is passed after directing the judge, degree holder to pay the subsistence allowances, Lordship. Fifty-one.
You received a notice under section 13? Have you received a notice under rule 13 or 37?
Yes, we did receive, Lordship. We have, in fact, we have submitted one representation also, Lordship, before
Well-
the,
So you received,
process.
you received the 37 notice, right?
we have received that through WhatsApp, Lordship, in fact. Lordship, there was no bad faith on our part, Lordship, that we were absconding or we are running away from fulfilling the liabilities that I had with the respondent, Lordship. Now, committing the person into the civil imprisonment has to be the last resort, Lordship, after every inquiry is conducted, Lordship. And if the learned court below, Lordship, finds that he is absconding or he is running away from his liabilities, then only the last resort is resorted committing him into the civil imprisonment.
But you, now you are saying that like section 40, order 40 also not, this thing, rule 40 is also not complied with.
Correct, Lordship.
Are you saying so?
Correct, Lordship. I'm saying that the learned executing court ought to have conducted a inquiry, Lordship. Summary inquiry, Lordship. As I'm contending, Lordship, that at least that basic thing has to be seen, Lordship, well conducted that inquiry, Lordship. Whether I'm absconding, I'm running away, Lordship, from my liabilities, all those has to be seen, Lordship.
And this was the first date when the order was passed. This is 16/2.
No, Lordship, this is not the past date. Several notice was sent to me through WhatsApp, Lordship.
Mm.
I have been replying to those
But you
notices.
are not
Lordship.
appearing.
Lordship, I have appeared before the executive magistrate also, Lordship.
No, I mean, this assistant commissioner. Have you appeared before the assistant commissioner? No.
Page 39, Lordship. I have appeared and submitted this representation, Lordship,
Before whom?
before the executing authority, Lordship.
Huh?
Before the executing authority, Lordship. Before the
Assistant commissioner?
correct, Lordship.
Huh?
Yes, Lordship.
Where page?
Page 39, Lordship. Mm. Through this representation, Lordship, I have sought 12 months time to repay that amount, Lordship.
But
I
who
was,
is not appearing again?
Lordship, I have appeared
You
on
are
this
fond
day.
of writing representation, but not fond of appearing. before
Lordship,
court.
while submitting this, I have appeared, Lordship. Page 40 also, Lordship. Down below, Lordship will find the receiving seal and signature of the concerned authority, Lordship.
I mean, what is the point of writing this when the one court has already passed an order? And this is only before the execution court.
Lordship, since beginning, Lordship, I am not running away from my
Yeah, running away
liabilities.
is
Lord.
not the thing, that you are not paying the money, that's the thing.
So why,
If
Lordship,
somebody is
I
running
had
away but
certain,
not paying the money,
Lordship, I had certain financial,
and you did not appear before the trial court also, I mean, that customary court. You have not appeared before the customary court. An order was passed. What this court can do now? And here also, before before the assistant commissioner also, it doesn't look like that you have appeared. We can issue only notice in this stage. We'll have to see the court records. We'll have to see, I mean, without taking into consideration those things at this stage, I mean, release will be difficult.
Lordship, this judgment that I have placed,
No,
Lordship.
that is fine. I mean, that has to be seen. That's why that has to be seen. I mean, how the, I mean, execution court proceeded. So records of the execution court will be necessary. Because if sufficient notice have been given to you, in spite of that, you have not appeared. And you have been only writing this representation that give me some time, that will not do. So the court also have, that executing court also should have the opportunity to find out what is the matter. But you have not given an opportunity to him.
Lordship,
So
in fact,
because you are not appearing. You are,
Lordship,
you-
Lordship, I have appeared, Lordship, page 46,
So
Lordship.
that's what, I mean, now that whether you are appeared or not, and how many dates have gone like that, that has to be seen from the records.
Lordship,
Or-
page 46, Lordship. In fact, I have given in the form of security also, Lord, one.
No, that
Check,
we have seen.
Lordship.
I mean, you give a blank check or whatever, those things will not.
Lordship, these citations that I'm placing, Lordship, George, Lordship, Jolly George, Lordship.
This one, I mean, that undated check. When did you submit? Where do you have submit?
Lordship, along with this representation, Lordship, 21, 11,
You say
20.
you don't have money, but how you are giving this check?
Lordship, as a security, Lordship, that since I am seeking time, Lordship, now these citations that I'm placing, Lordship, I'm trying to press upon your Lordship that I'm not a dishonest defaulter, Lordship. Now, until unless the executing court finds that I'm a dishonest defaulter, Lordship,
Your
They cannot promise that.
dishonesty is apparent from the fact that you did not appear.
Lordship, since day one, Lordship, I have been admitting, Lordship, that
You are not.
I'm
See, there is,
I'm not denying the
as
Lordship.
far the loan is concerned, you cannot admit because that agreement is there. So you cannot admit, you cannot deny that, right? So, but I mean, if you once, I mean, at one, I mean, and on the one hand, you are saying that like I'll pay, but you kept on taking time. You're not appearing before the court.
Lordship, I was only seeking time to repay it, Lordship. Lordship, I was not saying that I will not repay it, Lordship. I was just taking
Do you think time will be
Lordship-
given for eternity? I mean, like you will keep on asking time and like somebody will give you back.
Lordship-
You have agreed to return him back within certain point of time.
correct, Lordship, but
Within certain point
certain
of time.
financial difficulties and
Financial
medical
difficulties that it should have not-
emergency cropped up, Lordship. That all those things, Lordship, I have reflected in my representations, Lordship. Since, Lordship, what I am trying to submit is, Lordship, since day one, Lordship, I am not trying to be a dishonest defaulter, Lordship. Now, the executing court also, Lordship, they ought to have conducted a preliminary inquiry under rules
You have not
40,
appeared.
Lordship. Lordship, I have appeared, Lordship. I have submitted several representation before the authority
I mean,
concerned.
whether you have personally appeared or not, there is nothing from the record to be seen. Whether the similar manner you have filed only representation. And there is nothing on record saying that you have submitted representation.
Lordship, as per instructions, Lordship, I am told that he has appeared, Lordship.
Only your counsel was there on the date of this thing. But Mr. You are J. Jimmy. J. Jimmy. J. Jimmy, the learned
J. Jimmy.
counsel, appearing for the petitioner. This is an application under section 115 of the Code of Civil Procedure, 1908, read with 227, Article 227 of the Constitution of India for washing and setting aside of the impugn order number AC stroke NLG stroke estate dash 01 stroke 2025 dated 16/2/2026 passed by the Assistant Commissioner Naharlagun and the underlying MEL order dated 18/7/2025 passed by the customary court, Model Village. The matter pertains to a loan transaction originating on 15/12/2023, where the petitioner had borrowed a sum of rupees 18,75,000 from the respondent, who is a close relative of the petitioner. Since the petitioner, you did not pay any money, not a single penny.
Lordship, at this stage also, Lordship, I am ready to pay certain
No,
amount.
no, no,
Lordship.
till now you have not paid any money.
No, Lordship. There are certain financial difficulties, Lordship, as I have been highlighting, Lordship.
While, right, since the petitioner was not paying any money, the dispute went to a complaint was filed before the customary court, Model Village by the respondent, and thereafter on the receipt, thereafter a notice dated 4/4/2025 was issued by the customary court, Model Village to the petitioner. Full stop. On receipt of the notice, the petitioner filed a reply on 18/4/2025 stating that he is willing to pay the loan amount, but due to certain financial difficulties, he was unable to pay the same. It is the case of the next para. It is the case of the petitioner. That petitioner has filed several representations before the model and before the customary court, Model Village, stating his willingness and bona fide to pay back the loan amount to the respondent. However, he sought 12 months time to arrange the funds and settle the matter amicably. Full stop. The petitioner submitted another detailed representation dated 23/5/2025 before the head Gaon. Head Gaon was a different person, right? Head Gaon regarding the notice dated 19/4/2025 issued by the customary court of Model Village. Full stop. Since the petitioner was not appearing before the customary court on several dates while submitting representation after representation, the model court and the customary court of Model Village, Naharlagun, by dated 18/7/2025, an ex parte order was passed whereby whereby in the findings of the aforesaid court, it has been decreed now wherein the findings of the Morgan court, it has been shown, he has been shown as to be deliberately absenting himself from all the hearings despite proper service of notices. Accordingly, what is this?
Regarding that, the subsistence allowances, Lordship, it has to be paid before he's arrested or after, Lordship. Phase six,
Which para?
phase six, second paragraph, Lordship. Under order 21, rule 31,
That is clear, that is clear. But where is the finding? That says only the rule. Where is the finding in this case?
Lordship, in here also, Lordship, the same contention was raised and the court has interfered, Lordship.
You please, give me the facts and the findings of the court. You are only saying that the rule is, I am also aware of the rule. The rule says.
Lordship, paragraph, page 10, paragraph 12, Lordship.
Phase 10,
Paragraph 12, Lordship. Last paragraph is the observation. Lordship. Having regards to the above view of
One
the
second.
High Court.
What was the last line? Accordingly, the case was decreed ex parte with the following. Number one, you write the respondent in quotation, you write the respondent Sri Likha Rajnik is directed to pay the full claim amount of rupees 18,75,000 to the petitioner within 30 days from the date of this order. Then we write number two, for willfully absenting himself from all these hearings, the respondent shall pay a fine of rupees 15,000 as a defaulter fee and the provisions of Arunachal Pradesh Civil Code under the provisions of the Arunachal Pradesh Civil Code Act 2021. Number three, penalty for penalty false stroke wrong FIR against petitioner rupees 1 lakh equivalent to 1 mithun. Rupees 1 lakh is 1 lakh is imposed on the respondent. Number four, the petitioner's right over the security land measuring 15 into 25. 18 cross 25 is equal to 450 square meters situated at Rayo Village, Missouri is confirmed in decree. It was further directed that in default in payment within 30 days, the following recovery measures shall be initiated. Number one, in small Roman 1, the petitioner's movable and immovable properties may be attached for recovery. 2, appropriate legal proceedings may be initiated for breach of court order. Then C, number 3, the decreed land shall remain with the petitioner as per the original agreement. It was also mentioned that the concerned authorities, including DC Capital Itanagar, EAC, dash Naharlagun, officer in charge PS Nizuli, and officer in charge PS Naharlagun are requested to assist the enforcement of this order if required. Next, when the matter was placed before the Assistant Commissioner Naharlagun for execution, the petitioner Jalen received notice of appearance dated 1/9/2025 issued by the Assistant Commissioner. However, the petitioner submitted a representation with the 15/9/2025 before the Assistant Commissioner, seeking 12 months time for clearance of the debt due to these financial constraints. Right, like that, when the matter was placed before the Assistant Commissioner, execution should stroke 7/2025 dated was registered. on 16/9/2025 also. The petitioner received another notice from the Assistant Commissioner. And against that also, he has submitted a representation dated 15th October 2025, seeking 10 days extension to settle the decreted amount. Full stop. Thereafter, on 16/2/2026, the Assistant Commissioner Nahalogun issued warrant of committal of dozen debtor to jail, wherein it has been mentioned that the judgment debtor has not published the decree nor satisfied the court that he is entitled to be discharged from custody. And therefore, he was directed to be sent to civil prison for 2 months or until the said decree is fully satisfied or the said judgment debtor is otherwise entitled to be released according to the terms and provisions of section 50 of CPC 1908. The court, the aforesaid court, further fixed rupees 200 per day, equivalent rupees 12,000 as the rate of allowance for 2 months for subsistence, for the subsistence of the judgment debtor during the confinement under the warrant of committal. Full stop. Accordingly, on the same date, that is 16/2/2026, when the judgment debtor was produced before the court of the Assistant Commissioner Nahalogun. After hearing the counsel appearing for the parties, the learned Assistant Commissioner was committed to civil prison for a period of 2 months. And it was directed to the decree holder to deposit the subsistence allowance of the rate of rupees 200 per day for 60 days amounting to rupees 12,000 before the superintendent of district jail, Julli. Full stop. Accordingly, the next para, it is seen that from the date of his committal to the civil committal to the civil prison on 16/2/2026 till then he is in civil prison. He is in civil imprisonment. The learned counsel appearing for the petitioner submits that there are violations of uh, violation of order 21 rule 37 in the instant case as no subsistence allowance.
39, Lordship. It should be ordered, Rule 39.
Rule
39.
39 or 37?
39. Rule 39, sub rule 1.
Order 21 rule 30. Yes, rule 39. Rule 39 is complied with as the judgment debtor was arrested before the decree holder paid the subsistence allowance to the jail authority. He further submits that the he further submits that warrant was issued without taking into consideration relevant facts, more so his willingness to pay the loan amount. Issue notice to respondent returnable in 2 weeks by a speed post as well as normal course. In the meanwhile, the interim will be difficult in this case.
Lordship, like kindly consider, Lordship. Lordship has seen apparently the procedure has.
I mean, see, you have not been appearing. You have not, your conduct is not good. That's why warrant is had to be issued. Now, warrant of committal was issued taking into consideration all those facts. So,
Lordship judgments, Lordship that I have placed. Lordship.
here the
Very-
judgments we have placed were the factually different, where there what happened without considering anything, on the very first date, they have issued the warrant.
Lordship,
And that was the factual situation in both the cases. that was the
Lordship,
case.
here also,
So
Lordship,
here
at
it,
least,
here it was not the first day. You have been given sufficient time. See, order was passed on 5/9. Order was, this order was passed. Initial notice, you have, see, this first order of this customary court was on 18/7. Correct? Then you received the notice of 192025. You did not do anything other than writing this this representation. Then again on 15th October, you have written a representation. Then you have been heard on the date of this warrant, issue of warrant. Correct?
Lordship,
So,
basic,
so it's not that without hearing you, without giving any opportunity, the assistant commissioner has issued the warrant. It is not the case here.
Lordship, basic procedure that the executive court has to be satisfied that I have a means, even after having the means, I'm not paying, then only the option of the committal before the
That-
civil prison is
I mean,
taken into
that
consideration.
shows with your conduct that you did not appear, you did not bother to appear.
Lordship, since
Before-
day one,
before
Lordship,
the
I have been,
From the day one, you are not appearing.
Lordship,
From the
Lordship,
day one, you are not appearing before the
Lordship,
customary court.
that is correct,
So
but
that shows your conduct. So
Lordship-
conduct has to be taken into account.
Lordship, all those,
I mean, had you been appearing, showing your bona fide, that would have been a different thing. Writing a representation before the court where you have been given a notice to come and appear. You do not appear, you did not appear. What is your conduct?
Lordship, day one,
Now,
Lordship,
now when the ultimately you have been put behind the bars, now you are coming to running, you are, I mean, coming here running.
Lordship, ultimately,
This is
Lordship,
not the way to do it.
Lordship, ultimately, what I was, since day one, what I was trying to submit is that I don't have the means right now. I'm ready to pay it after some time, Lordship. If some dates are
That could have
given,
been-
Lordship.
That could have been done by appearing, by your appearance before the customary court. You did not.
Lordship, in my representation
No,
petition,
I mean,
Lordship, I
don't
have
think,
showed those,
I don't think we'll, let the other party come, then the court will decide, court will consider.
by that time, Lordship, the time will be,
So we are giving 2 weeks time. only, that's it.
Lordship, then I may be allowed to take justice service. So again, this,
Okay, then, in addition to the aforesaid notices, the petitioner is allowed, the
Lordship-
counsel for the petitioner is allowed to.
Lordship, may kindly consider my interim prayer, Lordship.
No, I'm not giving any interim, interim relief in this case.
Address, Lordship, after 1 week, Lordship, I'll be taking justice service less. There is
Okay,
a,
let the matter be fixed after a week. And the counsel for the petitioner is allowed to take justice, justice service on the respondent number, on the respondent. And thereafter file an affidavit of service of the affidavit as a proof of service of notice on the respondent.
Lordship, maybe listed after 1 week, Lordship.
Let the matter be fixed on fixed on 23rd.
20
23rd.
In their, Lordship, my interim. Maybe
On that date, the interim or the interim, that interim relief sought for by the petitioner will be considered.
obliged.
Item number 3. May I kindly take your lordship to page number 64.
Yes,
This is the order passed by the coordinate bench in earlier round of litigation. Misinterpreting this, the parwana has been issued.
64,
Yes, 64.
yes.
My lord, may kindly come to page number 67 from
Yeah.
paragraph 17.
Mhm.
In view thereof, the impugned decision of the Inter-Village Territorial Customary Court, Bangor Level Kaba, Obu Bangor Circle, dated 9/6/2025, shown to have been decided on 29/5/2025 is set aside.
Hmm.
Consequently, either party shall at liberty to approach the competent civil court under Arunachal Pradesh Civil Courts Act 2021, amended from time to time, for setting aside or fresh adjudication of the dispute relating to a plot of land, that is Kesarika, or in the alternative, either party may also approach the Inter-Village Territorial Customary Court or the Apex Customary Court, as the case may be competent under the AFR 1945. This was the order,
Correct.
only giving the liberty to either party to approach either Apex Court or Civil Court. However,
Civil code or approach
Inter-Village
Inter-Village
Territorial
Customary
Court or
the
Apex Court.
Apex Customary Court.
yes,
Yes.
but
Now-
in spite of approaching from any party, the
Then
defendant neither approach, neither the petitioner in CRP 70, they didn't approach. But the Bangor level Inter-Village Territorial Court sumoto issued the parwana, fixing Kaba, without there being any approach from either party. That is the case here. The parwana is at phase number
page
69.
69.
Yes, the first parwana, and the translated copy is 70.
So disputed land is Kesariki only.
Kesarika only.
Kesarika.
My lord, have seen only liberty was given to either party. Now the parwana at phase number 70 translated by.
This parwana was issued by Inter-Village Territorial Customary Court.
Yes,
So Inter-Village Territorial Customary Court, otherwise they have, High Court has directed that you can approach,
yes, that's
can
clear.
approach.
Either party may approach, but both the plaintiff and the defendant in the earlier round of litigation, they didn't approach before them. However, they have on their own issued the parwana, misinterpreting that the High Court has directed us to conduct the kaba.
No, but like SS Tamumai made an appeal on dated 8/12/2025 before me for hearing the case.
Yeah, that was earlier, that has been set aside.
No,
By
that was, no. One second. When is the order passed?
By
Court's order?
page 64.
What was the date? Date was 26/11,
Yes.
but it is subsequent to this.
No appeal was filed.
Hmm?
No appeal was filed, my lord.
No, they have stated that it is in file. Who is Tumli Mai?
Yes, that was the defendant in,
So
Earlier
he has,
round of
he has made an appeal.
no, that's why, Your Honor, that is the parwana. Then I applied for RTI of his complaint.
Hmm?
Then I filed an RTI before the head Gambura.
Where is that?
That is at phase number,
Head governor of what?
no, before the Inter-Village Territorial Court.
Where is that?
That is at phase number 88.
88.
Yes. Translation copy is 89.
88, yes.
Yes. This I filed. Issue of,
88 you filed.
yes.
You filed before the,
Same person who have issued the parwana. Actually, he is the GAM secretary of Uhubango.
but you have not, written to this intercourt.
He is the person who is who has the authority to issue parwana as assigned by them. As a
That
GAM
was- But
secretary.
that was issued by one court, so ideally you should have approached that particular court.
No.
Anyways, then go,
If my lord see the parwana,
no, where is the translation?
89. To so and so, Secretary Uhubango, so and so, so and so.
Issue.
Issue of complaint letter lodged by Sri
Complaint.
Tumlimai of Ignorak.
For you. As per the complaint you have earlier fixed Keba on thereafter for the second time. As such, I will issue the copy of CPC for the complaint. Now, where is it? Their reply?
No reply till that, only verbally stating that there is no complaint. High Court has directed me to conduct. That was the reply, verbally. No response, no the official response from him till there. Thereafter, again, he issued Parwana. That is at page number 99. So I am trying for stay of the cover and setting aside of this Parwana.
Hard this so and so, your name?
Emet.
M?
Ete. ETE.
M Kato.
ETE. Ete.
M Ite. M Ite, the learned counsel appearing for the petitioner. Appearing for the petitioner, full stop. This is an application on the under Article 226(7) of the Constitution of India, read with Section 115 of the CPC 1908 for setting aside and passing the impugned parvanas dated 16/12/2025, dated 19/1/2026 and dated 23/2/2026 issued by Sri Togam Ori, head Gaonbura, Bhumoy village as the Gaonbura secretary of the inter-village territorial court, Ibu Bango, fixing the Keva in bracket mail on 6/3/2026. The case of the petitioner is that provide an order dated
2611
26/11
in CR.
26/11/2025, the coordinate bench of this court has directed as follows. The quotation may you write, para 17. In view thereof, the impugned decision of the inter-village territorial territorial customary court in bracket Bango level Keba bracket complete, Ivo Bango circle dated 9/6/2025, shown to have been decided on 29/5/2025, is set aside. Then 18 you write, consequently, either party shall be at liberty to approach the competent civil court under the Arunachal Pradesh Civil Courts Act 2021 in bracket amended from time to time, bracket complete, for setting aside, or press adjudication of the dispute relating to a plot of land that is in bracket in quotation Kesa Wike, quotation complete, semicolon, or in the alternative either party may also approach the inter-village territorial customary court, or the apex customary court as may be competent under the Assam Frontier in bracket Administration of Justice bracket complete Regulation 1945, quotation complete. Full stop. It is a case of the petitioner that though the aforesaid direction was issued, direction was passed by the Honorable Guwahati High Court, none of the parties had approached the aforesaid inter-village territorial customary court by filing an application as in terms of the aforesaid order dated 26/11/2025. Full stop. However, the aforesaid Togam Ori, head Gaonbura, Bhumoy village has had Somoto had taken the cognizance of the matter, cognizance of the matter, stating that a complaint has been filed by, which page is that? Was that the
70,
Parvana
70 translated version.
78?
70, my lord.
No, first Parvana
First Parwana, my lord, 70 translation copy.
70.
Yes,
Translation copy
70 is at 70.
stating that Sri Tamul Mai, Sri Tumli Mai made an appeal on appeal before the inter-village customary court on 18/12/2025 for hearing of the case. Full stop. It is the case of the petition that after receipt of the parwana, the petitioner approached the aforesaid inter-village customary court for certified copy for a certified copy of the complaint that has been filed by aforesaid Tumli Mai. However, till date, no copy of such complaint has been served upon them. Full stop. Served upon them, and nor any response has been sent to them. However, subsequent to the aforesaid initial parwana dated 16/12/2025, two more parwanas dated 19/1/2026 and 23/2/2026 were issued to the petitioner. Full stop. The learned counsel appearing to the petitioner submits that the direction of the Honorable Guwahati High Court was specific to the effect that only on a complaint or approach by any of the parties in the aforesaid case, that is WPC number. What was the number?
CRP 70/2020.
CRP
70
number
2025.
Could have approached the aforesaid inter-village territorial court, but in the instant case, none of the parties had ever approached the aforesaid court. Rather, the matter has been taken suo motu by the inter-village territorial court, making a false assertion that one of the Sri Tumli Mai has filed a complaint. He submits that though he has repeatedly approached the territorial inter-village territorial court for the copy of the complaint, however, no response could be gathered from the opposite inter-village territorial court. Full stop. Next, taking into account the submissions made by the learned counsel appearing to the parties and after perusing of the materials, perusal of the parwanas, the perusal of the aforesaid judgment and order dated 26/11/2025, passed by a coordinate bench of this court. This court is of the opinion that at this stage the aforesaid parwanas, that is 16/12/2025, 19/1/2026, and 23/2/2026 for to be stayed at this stage until further orders. Full stop. Issue notice to the respondent number. Issue notice to respondent number. The issue notice to the sole respondent, returnable within 4 weeks by speed post as well as in normal course. Full stop. Let the matter be listed after 4 weeks.
Obliged, madam.
Item number 4. May I Lordship, this is a pre-arrest bail filed by the petitioner approaching this honorable court in connection with Pasca PS case number, which has been registered under section 69 of BNS. That is a false promise of merit.
Lordship, here the petitioner is a casual labor in Department of Power. What has happened, Your Honor, in this matter? Your Honor, the petitioner and the complainant were in a relationship, Your Honor. And yes, the Lordship, to be,
Yes, Mr. MS Genie,
His Lordship may call for the CD, Your Lordship.
why CD is required in this matter? There is nothing.
Yes.
What you will get from the CD?
Your Lordship, if there is any documents that they have submitted or otherwise any,
See, I mean, this is a case, I mean, it's a matured lady of 33 years,
Hmm.
got into a relationship. Maybe there are certain issues cropped in. See, maybe there are differences. Now, she's alleging that false marriage and all that's section 16. At least just let him go. He, I mean, whatever, I mean,
Yes,
the distribution is there, he'll cooperate. He'll appear before the final, for the investigating officer.
yes, Your Lordship. In fact, there was also steps taken for mediation, Your Lordship, pre-counseling before registration of the FIR.
But it was that failed.
Yes,
Yeah.
it was on 6/2 and finally the FIR was registered on 27/2. Yes, Your Lordship. I don't have any issues.
Okay, heard, Mr. So,
We-
your name?
V. Jamo,
The Jonas, the learned counsel appearing for the case applicant, also referred me MST Gini, the learned APP for the state. And this is an application under the writer, application under seven, and FIR was lodged on
6/2 of 2026, but it was registered on 27/2, Lordship, that, the FIR is on page 15, Lordship,
page
page 15, Lordship, annexure 2
15.
is the original, Lordship. It says, Lordship, received at PS on 6/2 of 2026, in the top,
On
Right.
FIR was lodged on 6/2/2026.
but registered on 27/2 of 2026.
Where is the registration date?
Down below, Your Lordship.
Down.
So,
Complaint received from OSD and on.
An FIR was filed on 6/2/2026, which was registered on 27/2/2026. By the officer in charge, Omen Police Station, Pasighat, lodged by one Sima Pang, or lodged by the informant, alleging inter alia that she entered into a relationship on 17th February 2025 with the accused applicant. And from the very beginning, the accused applicant represented to her that he would be marrying her. And then semicolon that on the basis of such promise, the informant got involved in physical relationship with the accused applicant. Semicolon that the families of the families of the accused applicant as well as the informant were aware of their relationship, and in fact they had been staying as husband and wife. However, semicolon on that, however, suddenly, sometime in January 2026, the accused applicant started avoiding her and abandoned her after sexually exploited her. Then right, that a male was called for, a village male was called for, wherein the families of both the parties were present. However, however, nothing could be arrived from the male as the accused applicant was adamant of not marrying her. On the basis of the FIR, that on the basis of the FIR, police registered police registered Pasighat Women PS case number 5/2026 under the aforementioned sections against the accused applicant. The learned counsel appearing to the accused applicant submits that though he got into the submits that the informant is a lady of 33 years old and she in fact got into the relationship with the accused applicant without disclosing her past as she was a married woman with a child of 5 years.
Yes, sir.
5 years. He submits that the accused applicant did not, accused applicant was not aware of such past history of the accused of the informant, and though he entered into a relationship, there was no promise from his side to marry her. However, on realizing that the informant is already married, informant was already married, and her marriage was still subsisting, he denied to marry her to stop. Therefore, he submits that there is no offense committed by him, and an offense committed by him. However, since the FIR has been filed, he is apprehended marriage, and therefore he will approach this court by filing the instant PSBL application, MSPG and PSBL application. He submits that the accused applicant will fully cooperate with the investigation in the event of his where is allowed in the instant application. And then on the other hand, MSP Jimmy, APP submits the case that in the instant case to be considered before allowing the prayer of the accused applicant in the instant case. This court has heard the submission made by the counsel appearing to the respective parties, and also consider the material that has been brought before this court by this application. On consideration of the entire facts of the case, this court is an opinion that at this stage the accused applicant should be given the privilege of prayer as well. Accordingly, it is directed that in the event of arrest of the accused applicant by accused applicant, he shall be released on punishing of a bail bond of ₹20,000, which is security of life nature, to the satisfaction of the arresting authority, satisfaction of the investigating authority, subject to the following conditions. One, you write those three conditions. Normal condition. You did 10 days appearance and cooperate, not to temper. In view of the aforesaid balancing, the instant heavy application is disposed of.
Item number 5.
May I, Your Lordship? Sorry.
None is appearing.
Seems. What councillors?
Rakesh Chhatri, Devo Sharma, none is there.
None is present
Okay,
today.
we'll pass it over for time being.
Item number 6.
May I, Your Lordship?
Yes.
Your Lordship, the present bill application number 21 of 26 has been filed in connection to Bandardia PS case number 22 of 20, Your Lordship. This is my second bill application. The first one was rejected before the Sessions Court UPR, that being BA number 515 of 2025.
Yes, Mrs. Jini.
Your Lordship, there is another bail application pending before this court, Your Lordship. But another accused, Your Lordship. Both their bail was rejected on the same date, Your Lordship.
Bail
The
was
same-
rejected.
Yes, on in the trial court, Your Lordship. Now, this matter is also pending, Your Lordship. On the last occasion,
it was to be listed on 2nd of March, but then during that, on particular date, due to paucity of the time, the matter could not be taken up. If I may pray this, both this matter be taken along together and be listed together.
We'll hear it on Monday.
TCR is called.
Yes, TCR has also been called in that matter, Your Lordship.
It has come.
The registry would know about.
Day before yesterday, it was fixed before the sessions court. So I don't think it has been sent
Fixed before a session court for what?
for evidence.
For
It's been
evidence.
5 years, more than 5 years, still.
Okay, then CD may not have come.
The TCR, Your Lordship.
So PCR may not have come.
Yes, yeah. Otherwise also scan copy of the TCR was,
Okay,
Call for
we
it.
write hard, miss.
SV Dharam.
There are
At
learned
least
counsel, appearing
State
at
Defense
the
Counsel.
it is applicant also heard MSPGE, the learned APV for the state. It is submitted by the learned APP that a similar bail application,
Monday.
Your Lordship, BA number 8 of
similar
20,
bail application arising out of the same case. Being bail application number,
BA number 8 of 2026, Your Lordship.
so is also pending before this court and same is to be listed. Same is to be listed in the next week. No direction was
No direction was given.
is pending before this court wherein the CD wherein the
LCR.
TCR
TCR.
was called for to stop. In view of the aforesaid, the learned APP submits that the instant bail application should be also heard together with the aforesaid bail application full stop. Taking into account the submissions made by the learned APP, it is directed that the instant bail application is to be tagged with the aforesaid bail application, that is bail application number so and so, and to be listed on Monday. It will come TCR. From which court?
From UPR.
UPR court, Your Lordship. I have seen the entire record, Your Lordship. The entire record is of this bulk.
Bulky, so that
And
will be
therefore,
able to scan it. It will not be possible. So let it
As
be.
soon as
Your
the
Lordship,
TCR,
Earlier,
otherwise,
earlier one bail application has already been allowed from this court.
I understand,
yes,
I understand that, but thing is that we'll have to see the TCR also. And the other case has to be also heard.
Yes.
So Monday, it may not be possible probably.
as soon as the TCR comes,
Your Lordship,
otherwise,
any
Your Lordship.
fixed date.
We will try sometime on 18th.
18, Your Lordship.
18th, let us try on 18th.
Yes, Your Lordship.
Let both the matters be fixed on 18th.
Of DPO.
Matter number 7.
None appeared for the petitioner. You are there. To make it fast, brother. Yes.
This is a joint petition, Malak. Joint petition.
Joint petition.
Yes, for quashing a FIR and GR case, Malak.
Joint petition is difficult. What was the offense?
Offense.
Why it
for-
was
Forgery,
filed?
Malak. Forgery.
Forgery.
Yes, Malak.
How much? I mean, what have you done?
No, nothing, Malak.
Hmm?
The allegation is that, Malak, the petition number 1, 2 has filed a FIR, Malak. Alleging that I have signed. Petition number 3 has signed in the power of attorney in the name of petition
Power of
number 1
attorney
and 2
forward. Power of attorney forward.
for filing Malak, court cases, Malak. For filing court cases on behalf of the claim, Malak.
You are a company or
No,
what?
no, we are from same claim, Malak.
Hmm?
We are from same claim.
You are from the same clan.
Yes, Malak. So for compensation matter, we had to file writ petition and other cases.
Compensation for land.
Yes, Malak.
Okay.
For a common cause of the claim members. Malak.
So declare
With the power of attorney.
petitioner number 1 and 2 has alleged that you have forced
Their
his signature.
Yes,
Forced their signature
yes, Malak.
and executed the power of attorney.
Yes, Malak.
And with that power of attorney, you filed some cases.
Before
Yes.
this honorable court.
We have filed some cases before this honorable court.
Petition number 3.
Petitioner
Now,
number-
Malak, they say, petition number 1, 2 say, Malak, it was under misunderstanding. Malak. Malak, may kindly come to page 30, Malak.
is 30.
Yes, Malak.
The case is still pending.
No, Malak. Oh, but GR case is pending, Malak.
No, that High
Writ
Court
petition.
matter.
No, no. Page 30 will clear it.
This is an affidavit filed by whom? Signed by whom?
By the petition number 1 and 2, my lord.
One is Teki Zenpen
Yes, my lord.
and
That's-
other one is,
Other one is the father, my lord.
Huh?
Is Tako Janpen.
what is the name of Tako Jampen? Yes,
Yeah,
Tako
page
Jampen.
31, my lord.
Tako Jampen is the son.
Tachi Janpen, yes, Tako Janpen is the son, my lord, yes. Tachi Janpen is the father. My lord, may please, para 3, my lord. Page 30, para 3, my lord. Of the affidavit, my lord.
There are three.
Yes, my lord. Para 2 and 3 is relevant, my lord.
Yes.
The FIR was closed on so and so based on the allegation of forgery of our signatures on a power of attorney, no litigation from an authorization letter. However, upon further reflection and discussion, we have come to realize that the matter arose from a misunderstanding. That we, the complainants, hereby wish to withdraw that aforesaid mentioned FIR against the Tagam Janpen. We acknowledge that the signatures in question were signed by us. And we do not wish to pursue any further litigation. This was in fact also submitted before the IO of the case, my lord. Page 28, my lord, before filing of the charge sheet, my lord. This is of 2024, my lord. 12/8/2024. My lord, charge sheet was filed on 7/2/25.
What is the charge sheet?
Charge sheet page 28, it starts from page 24. my lord. In the body of the charge sheet also, they have, the IO has mentioned, my lord.
Where is that?
Page 28, my lord.
Hmm.
Third paragraph. my lord. Further, on 4/9/24, a copy of settlement and withdrawal of complaint affidavit received from Sita Johnson, so stating they have come to realize that the matter arose from misunderstanding and wish to withdraw the FIR and against Sri Tagam Janpen. Further, they acknowledge the signature in question were signed by them. They do not wish to pursue any further legal action.
Okay, Ms. Zini.
Yes, Your Lordship, I would, if Your Lordship call for the TCR, because even there's an FSL report, which also to be considered. Because
No, it's not, they have admitted it. I mean, there is a forgery. The forgery was committed, I mean, whatever, but he has admitted that a sign was done.
Yes, madam.
Correct. We have
Yes.
done, we have taken their sign.
Yes.
We are admitting the forgery. It's not that we have not done
No, the
it.
petition number 1, 2 have acknowledged, madam. They have accepted, they have signed the signature now. They have signed. In the power of attorney, they have signed.
They have signed.
Yes.
Where is that?
In or the affidavit, madam, just before I read.
page number 30,
Yes, page 30, madam.
this
That
is,
they have signed, where is that?
Yes, 3, madam.
Three, the
Yes, there are
complainant
three.
server is to withdraw from. We acknowledge that the signature in question were signed by us.
Yes, madam.
this was by both the complainants, Your Lord.
See, this is a matter which is personal to them, right? And I mean, I don't think there will be any impact on the society or
Yes,
something like
these
that.
are
In-
private.
This is not a heinous crime. So in that view of the matter, I think this can be compromised.
Yes, Your Lord.
This can be compromised.
No issues.
I mean, in this. Right, heard Mr.
B picture.
Hmm?
B picture.
B. Picha.
Yes, madam.
B. Picha, the learned counsel appearing for the petitioners, appearing for the petitioners. Also heard Ms. P. Jimmy, the learned APP for the state. This is an application under section 528 of BNSS 2023 for causing and setting aside Moinong Police Station case number 01/2024 dated 24/1/2024 registered under section 465 stroke 466, stroke 467, stroke 468, stroke 472, stroke 473 of Indian Penal Code 1860. And subsequent charge sheet number 1/2025 dated 7/2/2025, which is presently pending before the Court of Chief Judicial Magistrate Alo, District West Siang, Arunachal Pradesh, as GR case number 202/2024. The facts of the case is that the petitioner number 1 and 2 had filed a complaint dated 18/10/2023 against the petitioner number 3, alleging that the petitioner number 3 had forged the signature of petitioner number 1 and 2 in a power of attorney so as to fight for common cause of the Saji plan before the court. However, due to non-registration of the FIR, the petitioner number 1 and 2 that filed CR case number 31/2023 before the Court of the Chief Judicial Magistrate, Alo, West Siang District for registration of the FIR against the petitioner number 3, full stop. Accordingly, wide order dated 14/12/2023, the learned CJM Alo, West Siang District directed registration of the FIR, full stop. Registration of the FIR, and FIR was registered, registration, and accordingly, Monigong Police Station case number 101/2024 was registered under section 465/467/468/472/473 of IPC 1860 against the petitioner number 3. Full stop. While the matter was pending, the petitioner number 1 and 2 realized their mistakes and informed the investigating officer of the case that actually there was no forgery committed by the petitioner number 3, and in fact the signatures appearing in the power of attorney belong to them. And the and they admitted that the aforesaid FIR as well as the complaint were in fact filed due to certain misunderstandings. They also stated that they have executed a settlement deed dated 12/8/2024. They executed 2 deeds over.
Yes, ma'am. 2 deeds, there are
2 settlement deeds
Yes.
dated 12/8/2024 and 13/8/2024. Amongst now with petitioner number 3, wherein they have decided to amicably settle the matter and not to pursue the case any longer, as the FIR was filed due to certain misunderstandings between petitioner number 1 and 2. The petitioner number 1, 2 petition number 1, petition number 2, and petition number 3. However, after investigation, after completion of the investigation, charge sheet was filed by the investigating officer wherein the aspect of wherein the fact of the amicable settlement of the an amicable settlement arrived at by petitioner number 1, 2 and petitioner number 3 have been specifically mentioned. Respect. The learned counsel appearing for the petitioners submit that all the petitioners belong to the same clan and reside in the same village.
Yes, same place.
The same
They are close relatives.
same village and in fact they are relatives. He submits that the FIR as well as the complaint was filed due to certain, they are literate people or what?
Literate people.
Huh?
Yes. One is the GB one.
Hmm?
Petition number 1 is the GB one.
No.
Petition number 2 is the son one.
The government is a literate person. Why he has falsely filed this? So means that the complaint as well as the FIR as well as the complaint was filed due to certain misunderstandings, and presently they have settled the issue amicably, and since they are close relatives and residing on the same village, they have agreed and settled to resolve the issue amongst themselves, and therefore filed this filed the instant petition jointly to quash the proceedings pending before which court?
CGM Halo.
Pending before the CGM Halo. He submits that this court has inherent power under section 528 of 528 of the CRPC to quash a proceeding, criminal proceedings when the parties have amicably settled their disputes and they no longer pursue the matter against the accused person. He submits that there are incatena of cases by the Honorable Supreme Court as well as by Guwahati High Court has allowed such way of quashing, and there were quashed the criminal proceedings pending before the trial court, which may not end up in conviction of the accused person. MSP on the other hand, what is your submission?
Your Lordship, I don't have any objection otherwise.
Mr. MSP the Learned Deputy has clearly submitted that since the issue is typically personal between the petitioner number 1, 2, and petitioner number 3, without having and it's not of any and the allegation is not of committing any heinous crime. The instant case can be in the prayer of the accused, the prayer of the petitioners can be considered by this court and closed can be considered by this court posted. Right. This court has heard the submissions made by the Learned Counsel appearing for the respective parties as well as parties as well as gone through the materials that have been brought before this court. On agreement of the parties, on agreement of the counsel appearing for the parties, this court has decided to dispose of the matter and the motion stays itself. Without calling for the trial court records. Please. The later part I will give, as same cases, I'll give in the channel. I'll allow this, I'll just quote couple of cases are there,
Please.
so
Yes.
I don't have those cases ready-made.
I have one of our High Court.
This place basis, which, give it to me, then I can probably finish it.
Here in para 11, this honorable court has one of observed is less serious. This is also forgery. Para 11, would be the relevant. 11, 12.
You're right, it is seen, that the petitioner number 1 and 2. Petitioner number 1, 2, and petitioner number 3 have already settled the issue by entering into two deeds of settlement dated.
Your Lordship,
Well,
there's
eight
only
would-
one deed of settlement. One is an affidavit. Your Lordship.
Okay, by entering into one deed of settlement, that is,
13 August 2026.
24.
where is that?
Lordship will find
Page
that in
30 and my lord, page 32. my lord. Page 31 is page 30, my lord.
Your Lordship will find the date in page number 38.
38,
Yes, Your Lordship.
agreement dated, you right, agreement dated 16/7/2024, as well as an affidavit dated,
13,
dated,
12.
dated 12/8/2024. Wherein it was specifically mentioned that the FIR as well as the complaint as well as the complaint was filed due to misunderstanding, and in fact the concerned power of attorney contained the signatures of petitioner number 1 and 2. In view of the settlement of the matter by the parties, and considering that the matter is not of and the offense alleged to have been committed is not of a major offense or any heinous crime, this court is the considered view, heinous crime having impact in the society, having major impact in the society, this court is of the considered view that the present case is one of the cases where the inherent power of this court under section 452 of CRPC 1973 could be invoked as the chances of conviction are too bleak and remote, and the continuance of such proceeding in the present case would be a futile exercise and abuse the process of law. The law relating to quashing of criminal proceedings in non-compoundable offences on the basis of compromise by the parties under section 528 of BNSS 2023 has been enunciated by the Honorable Supreme Court in the case of State of Madhya Pradesh versus Lakshmi Narayan and others, reported in 2019 5 SCC 668.
My lord, here I would like to rely on
680.
Yes. paragraph 15.5, where the Honorable Apex Court has said the offense which are private in nature.
Para 50 of the aforesaid case being relevant is extracted living below. इसको extract कर देना है यहाँ पे है it is there. Next para having regards to the facts and circumstances of the present case and considering that the petitioners have filed the petition jointly after having entered into a deed of settlement as well as an affidavit, and thereby compromised the dispute, compromised the matter, and also taking into the ratios laid down by the Honorable Supreme Court in the aforesaid case of Lakshmi Narayan Supra. This court is of the considered opinion that the instant case is one of the cases wherein the inherent power of this court under section 528 of DNSS could be invoked. Consequently, the criminal proceedings in GR case number 2/2024 under sections same section, no? Charge sheet and GR.
Charge sheet, my lord,
Same.
yes, my lord. Only
Same, huh?
460, yes, my lord. 466 was
466
was deleted. Yes.
Deleted.
uh, no, in the GR case, the same sections are there as per the charge sheet.
Yes, yes,
Whatever is there in the charge sheet, it is there. No?
yes, yes.
GR case number so and so under section 465, 467, 468, 472, 473 of IPC 1860. 1860 pending before the court of the chief judicial magistrate, Alo, District West Siam, Arunachal Pradesh, is hereby quashed. In view of the aforesaid direction, the instant petition is disposed of as allowed.
Deeply obliged. इधर ना उधर करता है ये बात पीछे ठीक लगता है जब आदमी में देखता है क्या बहुत लगता है
Lordship, in item number 5, I've just been informed by the council that since there was a declaration of one today, Your Lordship, he could not come to Itanagar, Your Lordship. If Your Lordship, as per his request, fix this matter on 11th, Your Lordship.
11th.
Yes, sir.
Today is what? Today is
Today is
5th.
5th. Yes.
Okay. On the prayer of the learned council. No, on the prayer of the learned deputy. Let the matter be fixed on 11th.
Repeat.
None appeared for the opposition. None appeared for the petition.
Item number 8.
Your Lordship, may I please? My Lord, the petitioners are this indigenous tribal people of Arunachal Pradesh from this Rumgong subdivision, Siang district, Arunachal Pradesh, my Lord. Your Lordship, in Arunachal Pradesh, the ownership of land is governed by tribal laws, my Lord. And in this Balipara Frontier Tract Zoom Land Regulation 1945, my Lord, there is clear this clear recognition and assumption of ownership of towards the private tribal people, my Lord, in Arunachal Pradesh. It so happened, my Lord, by impugn order dated 30 page 32, my Lord. Annexure 1, my Lord. Additional Deputy Commissioner Rumgong 32, my Lord. Your Lordship, he has issued, without any reference to the public, my Lord, he has issued this encumbrance pre-certificate of land, declaring our land as community land, my Lord. Based on this erroneous certificate, my
But
Lord,
why haven't you challenged it?
but we are challenging it here, my Lord.
No, now it's like it was issued in January 2025.
January-
Why you have come?
Your Lordship, number one, it was not known to us because even we came to know about it only after sanction, my Lord. Only after sanctioning of this 50 crore there, my Lord, we came to know, my Lord. And thereafter, my Lord,
What sanctioning?
based on this erroneous certificate, my Lord.
But you are aware that the project is going on, that road is going on.
My Lord, going on. Page number 34, my Lord.
Hmm.
Based on this, my Lord, Government of Arunachal Pradesh, through the Principal Secretary, PWD, has sanctioned 50 crore for widening the land, and now they are forcefully executing it, my Lord.
So you got to know on 10th of February.
My Lord,
Yes, till now what we are doing,
after that, my Lord, we made representation.
when,
My Lord, please come to page number 76, my Lord. My Lord. Page 76, my Lord. This is a type copy, my Lord.
yes,
Social impact assessment, we prayed for, my Lord. And after this, some assurance, verbal assurance was given to us. We visited this office also, my Lord, of this ADC. ADC, sir, at that point of time, he was inclining to have some assessment. But later, without doing anything, time passed by. He has let the education started, my lord. So that's why. And what he did later, my lord. First, he said that this land is community land. But on seeing our objection, my lord, he has issued another order, my lord.
30th October.
My lord. Yes, my lord. 30th October, my lord. Here he has clearly said this landowners. He has asked all the landowners, may I read, my lord, executive order? First, in his certificate, he says it is community land, land of known, my lord. He has said that. But here again on 30th October 2025, he has said, third para, my lord. Accordingly, through this executive order, an earnest appeal is made to all the landowners, occupant, and affected individuals whose land or standing assets fall within the proposed formation with a project to voluntarily vacate, shift, and remove any private standing asset, structures, plantations, or obstruction within a period of 30 days from the date of this order, my lord. Here, he is again saying your land, but you have to vacate it because the object and the aim of this project is of vital importance. We admit that, my lord, it is important, my lord. But our grievances here is, my lord, our tribal right cannot be curtailed that way, my lord. And regarding the land, my lord, your lordship, Arunachal Pradesh Land Settlement and Record Act, we have. It was passed in this 2000, my lord. In that land, in that law, my lord, government has no land. Government can have land only through two options, my lord. My lord, Arunachal Pradesh Land Settlement and Record Act 2000. It is given in Arunachal Pradesh volume, my lord, 7.
Arunachal Pradesh.
Land Settlement and Record Act 2000, my lord. My lord. It is in page 219 of the volume 7, my lord. Please come to section 2 and subsection H, my lord. H after G. H. Government land. In Arunachal Pradesh, my lord, what land becomes government land, my lord? Government land means land acquired by the government.
But they are not saying that there is a government land.
Yes, yes, my lord. They have not. Now, without their land, our question is, my lord, whether they can arbitrarily enter into our land, my lord, without our consent and without our donation, my lord. Your lordship, another provision, very important provision is there, my lord. Balipara Tirap Sadia Frontier Track Zoom Land Regulation 1947, my lord. It is in AP Code Volume 1, my lord. Page 73. Page 73. Volume 1.
Seventy-three.
Page 73, my lord.
Mhm.
Page 73.
That has been repealed.
My lord.
That has been repealed. Is it not?
No, my lord, I don't find this enforced because in 2024, there was a Amendment, my lord. Your lordship,
Balipara 47.
my lord. In 2024 also, there was an amendment. It is seen in volume 17, my lord, AP code. Volume 17. I think it is in force. My lord, I stand to be corrected by my this sister. If it has been repealed, my lord.
Lordship, if you will not take it, I say that Lordship, this will not come into play here, Lordship. This is CM's, this especially this scheme is from CM's fund, Lordship. It's that plan fund. Here, they don't have a Lordship compensation for that.
But like, I mean,
This
but
is-
whether it's a whether it's a CM fund or Prime Minister's fund, but if the land belongs to somebody, whether without following the due process of law, or without acquiring the land, whether you can use it.
This is the existing road, Lordship. This is improvement in the existing road. This is not a new road.
Yes, correct. Widening it, you're taking his land, na? You're utilizing his land. So if you utilize somebody's land
No.
without acquisition, whether you can utilize somebody's land. I mean, road was this much. Besides, there are houses. Now you want to widen, you want to widening it. So you wanted to take the land, right? So like if the houses are there, some people's houses are there, can you not, are you not required to go follow the process to acquire the land?
So especially in PMJSY also, Lordship.
No, whatever is the whatever with the scheme, can you take somebody's land just like that? For public purpose, private land?
That is his claim, Lordship.
No. I mean, whether,
This
no, what is your stand?
Lordship, right now.
Are you
I don't have
denying,
any-
no, are you denying that like you have not taken his land?
Also, this was in it Lordship have correctly observed, Lordship, it was in the first order was in 31 2020.
Correct, he was not aware of it.
But then,
Then he has given you a representation. We haven't considered his representation. And with the, yeah, from October, whatever you are doing. See, if somebody's private house is taken or private, whatever, the cultivation is taken, are you not supposed to pay him that? For that?
Lordship, in this also they have in here only it is written that in Chief Minister Fund there is no Lordship.
Chief Minister's fund is for utilization of the widening of the road.
Yes.
Or for the project. Correct. Now, Chief Minister has not kept any money for compensation. But is it that only because of that, if you take somebody's private land and utilize it for the public purpose without their any volition for that, without their donating it, without their saying that we don't want any compensation for this, can you take somebody's land like that?
Lordship, in that case, let me take instruction.
No, you have to take instruction. You have to take instruction.
This has come motion. Lordship. So
No, you'll have to take it, sir. You'll get opportunity to get. But we are asking you that his grievance is that like his land was taken and without paying any compensation
yes,
for the assets, whatever land, whatever.
yes.
So, I mean, without paying him, how can you construct the road? Let them take instruction. Okay.
What I have said is that I understand your Lordship's point of view, but then what I am saying is that there in this scheme there is no compensation.
Then
But
he'll have,
even
see,
in this
if
project-
you do not have compensation also, then you'll have to create compensation. You cannot take somebody's land, private land without paying him money. Can it be done? If somebody if the government comes tomorrow and take your house without paying you anything, will you, can it be done like that? There is a process of land acquisition. If government wants the land for some public purposes, there's a process. The government they can do it. But they'll acquire the land. There is a process.
In rural places, especially if in PMJSY also, there is no this compensation.
So government takes, private land just like that without paying anything.
For their purpose only, for their communication only, Lordship, for the public interest,
For the-
roads are built.
For their public, every public is involved. I understand the roads are being built for public purpose only.
Yeah.
But if the roads are being built, without paying if you take somebody's private land and without paying him, you can replace it. It cannot be done.
No, sir. In that case, no,
You
sir.
take instruction.
I'll write instruction, profit office, maybe listed that.
Notice to-
Your Lordship, if notice is to be issued, my lord, Your Lordship, small interim order is there, my lord.
No, it's going to be-
No, sir, because they have come. they
No,
have-
see, if we pass an interim order also, what will happen?
My lord,
Are you going to get the money?
no, not impending, my lord. My prayer is very limited, my lord.
Hmm.
At least you don't stop. You carry on,
Hmm.
but at least social impact assessment can be taken now also, my lord. In the interim, my lord. If it
Let
comes up,
them come back, that can be,
Yes, sir.
here and there, 1 week delay will not cause anything.
my lord, and short notice may be issued, like.
Heard this, sir?
Tijamo, my lord.
Jano, the learned counsel appearing for the petitioner also heard at MS,
G at the Lordship.
G,
G at.
GET, the learned, additional senior governor,
Yes, Lordship.
additional senior governor. But we are appearing for all the respondents.
I'm not, no, Lordship. There is one private respondent. I am for 1 to 3.
Appearing for respondent number 1, 2, 3, and 4.
4 is a Lordship. Construction.
Executive engineer or public, government of Assam, government of Arunachal
Arunachal
Pradesh.
Pradesh, my lord.
4 years, no, I am not for 5.
Yes, for respondent number 1 to 4. Full stop. The grievance, by filing the incident with petition, the petitioners have impugned. You have impugned, which of the orders you have impugned?
My lord,
Third,
page
impugned-
number 32, my lord, annexion one,
impugned-
Section 1.
impugned the order
my lord.
dated 30, impugned the order dated 13/1/2025
My lord,
issued by the additional deputy commissioner.
my lord.
Now,
My
comma,
lord, it is actually a certificate, my lord.
I'll write, Lumgong district, Lumgong district, Siang, Arunachal Pradesh. Whereby a certificate of availability of encumbrance-free land was issued. Stating, no, state certifying that certified that certain portion of land to be used for the improvement of road from Lumgong ADC headquarters to NH 13 at Patum in bracket CMC SRBT -2 in Siang district is a community land.
Yes.
Is a community land. Certified that the same is free from all sorts of encumbrances and therefore the same can be used for the project. Improvement, same can be used for the project, full stop. It was also certified that in view of it was also certified that forest and environment clearance are not required for this project, as the same is not going to affect any environmental issues. Full stop.
Apart from that, my lord, we have, because the impugned sanction order is premised on this erroneous certificate, my lord.
So the petitioners have also impugned the order dated 10th February 2025
My, yes.
2025, whereby the principal secretary PWD government of Arunachal Pradesh Itanagar accorded administrative approval and expenditure sanction not exceeding rupees 50 lakhs.
No, my lord, 50 crore.
50 crore, 50 crore. Being estimated cost of improvement of the road of the aforesaid road.
500 lakhs. 5,000.
The case of the petitioners is that the petitioners are local inhabitants of Rungmong Administrative Circle, Siang District, and they are the owner of, and they are the owners of the land which has been wrongly certified as community land. The petitioner's case is that after coming to know about the aforesaid project and the petitioner's case is that after coming to know about the issuance of the certificate as community land, as well as the subsequent administrative and financial sanction issued by the government authorities, the petitioners have submitted a representation representation dated 28/10/2025 before the government authorities for carrying out a social impact assessment of the properties affected by the proposed ongoing construction of the road from Rungmong ADC headquarters to NH13 at Patum. However, rather than responding to the aforesaid representation, the Office of the Additional Deputy Commissioner, Rungmong Siang District, vide an executive order dated 30th October 2025 made an appeal to all the land owners, occupants and affected individuals whose lands or standing assets fall within the proposed formation of widening of the project to voluntarily vacate, shift and remove shift and remove any private standing assets, structures, plantations or obstructions within a period of 30 days from the date of this order. So the petitioner's case is that the aforesaid executive order was passed without considering their representation as well as without giving them any hearing or notice to that effect. Full stop. This court, full stop. Let notice be issued returnable within 3 weeks.
3 weeks, my lord.
Returnable within 3 weeks. Notice to respondent number 1, 2, 3 and 4 is dispensed with as the learned additional senior government advocate is appearing for the respondents, for the aforesaid respondents. However, requisite number of extra copies to be served on the additional senior government advocate within a period of 3 days from passing of this order. Full stop. Notice to respondent number 5 to be issued by way of speed post as well as usual course within a period of 3 days of passing of this order. Let the matter be listed after 3 weeks.
Okay.
Matter number 9. Item number 9.
May, my lord. My lord, the petitioner advocate is from Guwahati, so maybe he's having some trouble joining through VC.
Hmm?
Maybe he's having some trouble joining through the VC.
So we'll fix it some other day.
My lord, matter may be passed over for some time.
Not time being. Some other day. VC request was given.
Yes, ma'am.
Time being passed over.
Item number 10.
My lord, this petition, my lord, has been filed for direction to the respondent authority to constitute a review DPC, my lord. As because, my lord, the fact of the case is, my lord, the petitioner was appointed as a inspector in the Department of Trade and Commerce way back in the year 2011, my lord, at page 33, my lord, on selection, my lord. Page 33, appointment order, my lord.
So you have been demoted
No, my lord, not demoted. After this appointment, I was given officiating promotion, my lord.
to TDO.
Yes, my lord, TDO.
Then you have been demoted again.
And thereafter, my lord, my submission, my lord, in the year 2015, I was given officiating promotion with regular pay scale of TDO, my lord. Thereafter, my lord, in 2016, my lord, the government has issued an office memorandum to all the head of department to constitute the DPC at least once in every 6 months.
Correct.
Now, despite of this standing order, they have not conducted DPC, my lord. And of late, my lord, violating the office memorandum, they have conducted DPC on 1st July 2020, my lord, wherein my officiating promotion to the post of TDO, madam, that has been regularized with effect from date of DPC, not from that when I was given officiating promotion.
So we'll have to hear them. We'll issue a notice at this stage.
My lord, that is why, in this case, my lord, only in the similar cases, my lord, they have considered and reviewed the DPC also. Even their file noting, they have speaks, my lord,
But
regarding.
we have to hear them. I mean, we have to hear them. I mean, at this stage.
My lord, that is, I agree, my lord. Only my respectful submission, my lord, since in the file noting itself, my lord, it's clearly the committee was constituted, and on the basis of committee, they have put up the matter to the authority, but this has not been considered, my lord. As a, my lord, pending disposal, I pray, my lord, my representation, my lord, may be considered, my lord. Because in the meantime, my lord, if they resolve it, my lord, because it seems that they are going, they are.
You want this matter to be disposed of?
My lord, only in respect of my representation, my lord, which is pending, my lord. In the meantime, merit will.
There will be no bar. We'll state that.
My lord, my lord, that observation, my lord.
Representation of Commissioner.
Commission, that's all right, my lord. No.
Okay, I mean, if, in the meantime, you can consider his case if it is, if you are doing, I mean, if you are considering other, some other, I mean, incumbents case.
Yes, my lord. Because I cannot be treated differently.
Mr.
T. Tagum, my lord. Tawa Tagum, my lord.
Learned counsel appearing for the petitioner also heard. Okay. Your junior government. Junior government advocates. You are appearing for?
All the respondents.
For all the respondents. The instant application has been filed by the petitioner. Petitioner assailing the order. Which page?
My lord, page, my lord, page 46, my lord. DPC, my lord, the 40. By which order?
Assailing the order dated 5th August 2020, issued by the Secretary, Trade and Commerce, Government of Arunachal Pradesh, whereby on the recommendation of Departmental Commission Committee held on 1st July 2020, the petitioner was regularized. The petitioner was regularized in the official, regularized
Officiating promotion.
officiating promotion of in the post of TDO, Trade Development Officer, with effect from the date of departmental promotion committee meeting, that is on 1st July 2020. Full stop. The case of the petitioner is that though he has been he has been regularized in the post of PDO, however he has been officiating in the aforesaid capacity from which day?
Malad,
From
21/12/2015, page 37, Malad.
25. Therefore, his regulation should have been from the date from the aforesaid date, that is 21/12/2025 to 21/12/2015, rather than from the date of the
DPC.
DPC, that is 1st July 2020. Full stop. Full stop. The learned counsel appearing for the petitioner submits that in the meantime the petitioner has already submitted a presentation for consideration of case before the respondent authorities by respondent office by dated which
Dated 10th March 2025,
10th
Malad.
March to 10th March.
10th March, 10/3/2025, Malad.
Long time back.
Malad, that is being considered, Malad, that is why, Malad, it is there in their file noting also, Malad. It's pending, Malad.
But why have you approached so late?
My lord, first representation I've submitted on 21, my lord, page 51. Thereafter, since it was not considered, my lord, then again subsequently, my lord, provisional.
Last one.
Last one, my lord, is my lord, 10th March, and thereafter again I submitted to CS also 10 March of 2025, my lord.
After that, you haven't done anything.
My lord, thereafter, my lord, they have
Okay, dated
10th March 2025.
However, though he has been verbally assured that his case will be considered, but nothing has been done till late. Full stop. In view of the aforesaid, he has approached this court by filing this instant petition. Full stop. Let notice be issued. Let notice be issued on the respondents. Internally within 4 weeks. 4 weeks. Full stop. Full stop. Formal notice is not required as the learned union government advocate is appearing for all the respondents. However, requisite number of extra copies of the petition shall be furnished on the union government advocate within a period of 3 days of passing of this order. Full stop. In the meantime, it is directed that the respondents will be free to consider the representation that has been the aforesaid representation dated so and so submitted by the petitioner before the respondent authorities. Let them appear be listed after 4 weeks.
Deeply obliged. Item number 11.
My lords, am I audible? I'm appearing virtual, my lord.
Yes.
My lord, this writ petition, my lord, raises a pure question of, my lord, statutory interpretation under the Arunachal Pradesh local authorities prohibition of defection after 2003, my lord. There is no factual dispute as to the election, my lord, party affiliation, my lord, or also a sequence of events. Now, the issue before my lord is whether the deputy commissioner could invoke section 5 subsection 2 of the.
Are you challenging some order of the deputy commissioner?
Yes, my lord. I'm challenging the order of the deputy commissioner, my lord.
Which is the impugned order?
My lord, the impugned order is at page 23, annexure A, my lord.
What is your prayer?
My lord, my prayer is to set aside this order, my lord, the impugned order passed by the deputy commissioner, my lord, and also, my lord, my lord has got the deputy commissioner's order, page 23, my lord.
Page 23.
Yes, my lord. The operating portion will be from page 24, my lord.
Yes.
The observation is from paragraph 6, my lord. May I read from paragraph 6, my lord? The Act was further amended in 2006 and brought about amendments to the APLA PD Act of 2003, namely Section 6.2 was amended, replacing state commission, so and so, my lord. Now, paragraph 7, my lord. My lord, we can skip that for a moment and page 25, my lord. Page 25. We can skip this for a moment and come to page 25, my lord. There, my lord, may I read from therefore? That's the observation, my lord. Therefore, upon careful examination of the records, documents and submissions and conjoint reading of section 5 and section 3 and section 5 of the Act, the following facts are undisputed. Number one, total members elected on BJP tickets 5, members opting for merger is 4, 2/3 of 5 members is 3.34. Therefore, the minimum requirement is 4 members. In the present case, 4 out of 5 members consisting of 80% of the total strength have agreed to merge, thereby satisfying the statutory requirements under section 5, subsection 2 of the Act, my lord. Now, some judicial precedence was wrongly relied, my lord.
This matter will require, this matter will require some consideration. Because
Yes.
The issue of interpretation is also there. So
Yes,
we'll
my
issue
lord.
notice at this stage.
My lord, and at the same time, my lord, I am also praying for staying of the elected members, my lord. Why? Because
No,
now,
no stay at this stage. No stay at this stage.
my lord, what happens here is, my lord, surely,
No,
my
no
lord,
stay at this stage. Let it be considered. I mean, let it be considered. It has to be, I mean, it will require some consideration. I mean,
My
at least, why should, I mean, some elected members, you are going to stay this.
my lord, because this is a my lord, what happened here is that this is a post facto, my lord, post facto merger, my lord. And when they were caught defecting, my lord, on the day of the election, then they say that we have marched already, my lord. There was no party resolutions, my lord. And on the day the GPC election was conducted on, and they've been following the party whip also. On 7th also party whip was issued. They abide by the rule of they abide by the party whip. And on the day of the election, that is on 10th, when they were caught, then they submitted a post facto merger, my lord. So, and the deputy commissioner simply went on to interpret section 5.2 without even interpreting section 5.1, because section 5.2 is only the deeming effect.
Correct. That has to be considered. I mean, this will require some consideration. So what we'll do is we'll issue notice at this case.
Yes.
And then we'll have to hear the matter at length.
My lord. Then in an early date, my lord, if my lord pleases, my lord.
Heard, Mr. You are Mr.
P. Yobin, my lord. P. Dot.
Yes. And the learned counsel appearing for the
Petitioner, my lord.
appearing for the petitioners. Also heard.
P. Sangeeta, Your Worship.
P. Sangeeta for
Government Advocate, Your Worship.
government advocate for respondent number
2, Your Worship.
respondent number 2, full stop. By filing the instant writ petition, the petitioners have essayed the interim order. You are only one petitioner, right? The petitioner has.
He's the general secretary, my lord. He's the general secretary of the Lowang Dibang Valley, my lord, BJP Morcha, my lord.
But like you are filing yourself only. I mean, for you only.
No, I'm filing as in the capacity of a party general secretary, my lord, of the district, my lord.
Where are you staying?
My lord, I'll just. My lord, the paragraph 1, that a petitioner is a general secretary of the Bharatiya Janata Party, Lower Dibang, as such, has a locus to maintain instant repetition for and on behalf of the district party, my lord.
Okay, but by filing the instant writ petition, the petitioner has, the petitioner has, the petitioner who is the General Secretary of BJP Lower Dibang District has assailed the legality of the order dated 10/2/2026 passed by the Deputy Commissioner, Lower Dibang Valley District, whereby the Deputy Commissioner, by the impugned order dated 10/2/2026 rejected the complaint representation dated representation dated 10/1/2026 filed by the petitioner praying for disqualification of private respondents on the ground of defection. Also, let the notice be issued on let the notice be issued returnable within 4 weeks. Notice to respondent number 1 is dispensed with 1 and 2.
Only 2, Your Lordship.
Okay. You are appealing for only 2.
Only 2.
Notice to respondent number 2 is dispensed with as the learned government advocate, learned junior government advocate enters appearance. Learned junior government advocate appeared on behalf of respondent number 2. Then you write notice to respondent number 1, 3, 4, 5, and 6 to be taken by speed post as well as by usual process within a period of 5 days from passing on this order. Full stop. Extra copy of the petition to be served on the junior government advocate appearing on behalf of respondent number 2. Let the matter be fixed after 4 weeks.
Obliged.
Obliged.
Matter number 12.
Your Honor, petitioner here is the laboratory assistant working in the Department of Health and Service, Government of Arunachal Pradesh. Petitioner here is the invoking the extraordinary jurisdiction of Honorable Court, being aggrieved by denial of promotion in the service of post of laboratory technician in Department of Health and Service, Government of Arunachal Pradesh. The petitioner are aggrieved because to the Department Promotional Committee, DPC, that had citing did not consider the case of
You have been working on contractual basis.
contractual basis. Sure.
So what right you have?
Your Honor, RR Rule 19, as per RR Rule 1900.
Rule. Contractual employee, what the right do you
No.
have?
Your Honor, actually we serve till now 18 years. 18 years.
Maybe 18 years, maybe 20 years. You're a contractual employee.
No, later they demoted as assistant laboratory. Post was actually sanctioned laboratory technician, but work was assigned as assistant laboratory, Your Honor.
No, you are working, you have been working on temporary basis, right?
Yes.
Now what happened?
Later demoted. Yes.
You are working in temporary post, temporary basis against sanction post.
Sanction post. Sure.
How many posts?
Total
How
now
many people are there?
48, Your Honor. We have 48 members.
Hmm.
And vacancy
Yours is you are individually or challenging? You have
we
individual
jointly
count.
individually.
Okay,
Yes,
then. So the petitioners were recruited, so petitioners were recruited and work, laboratory system, where they continuously work for science and post processing. The point of petitioners is laboratory systems. You have been regularized in the post of technical
Assistant laboratory.
when?
2017, Your Honor.
Then why you have come now?
As for
No.
Your Honor, actually,
Your case is that, you have been appointed, you have been taken on the job as this thing, as laboratory technician,
Laboratory
as
technician.
laboratory technician,
Yes,
and you have been working there for 6-7 years, against
9 years, yes,
9 years against sanction post.
sense in post,
Then you have been regularized.
regular, yeah.
Then you have been regularized in 2017
17, assistant
against sanction post of assistant
laboratory,
laboratory technician.
yes.
Now, after 2017, what have you been doing for so many years that you are now coming?
Your Honor, we have served several memorandum
2017 are now when
continuously, Your Honor, we serve.
you keep, I mean, still you go on submitting representation.
Finally, we even
Then you go on submitting representations.
legal notice, we've, Your Honor,
You
also
go
we
on
serve.
submitting representations, you go on submitting legal notice. That will serve your purpose. We have not come to the court. Now we have come to the court after 10 years of impugning a order whereby you have been regularized. You are challenging now after 10 years, almost 10 years, 9 years, right? So whether you have any right now,
Yes, Your Honor.
how,
Actually, same batchmate has been promoted, Your Honor.
when,
Same 2017. Order,
yes, but then what happened to him?
they are promoted as laboratory technician, Your Honor.
They
Same batch.
Correct. They have been promoted. Some people have been promoted to laboratory technicians. You have not been promoted. You were aggrieved, right? So cause of action arose when 2017. You should have come to the court immediately. You have not come. You kept on writing representations, but government did not respond to. Maybe responded also. But after so many years, why this court should entertain your case?
Your Honor, continuously representation and legal notice we
No,
shall submit.
that's what I'm saying. You keep on writing to them. They will give you something.
And their legal notice did not satisfy us as per our rule, 1999, Your Honor.
Whatever, I mean, the court is not denying that you may be having a case, you may be having a grievance, but you should approach the court in right time, right? There are principles of delay and lectures. There are a lot of other things are there. I mean, how can you file a petition when the cause of action arose in 2017 and you have been slipping over your rights? Now you have come after 9 years. How this court is going to entertain this? Your explanation is only that you have been filing representations. But filing representations will not do. I mean, if you sleep over your rights, then your right goes. Court cannot entertain in writ petition also certain matters beyond certain point of time if there is no proper explanation why you have delayed in coming to the court. There is a principle of delay in laches. Delay in laches is a ground whereby a petition cannot be entertained. That is your case or something else is there? That is your case. You are appearing for?
Malad, I'm for respondent number 2, Malad.
Who is who? Who is?
Sending counsel, Malad, for the health department.
What is your submission on this?
Malad, the petitioner, Malad, they were appointed under the National Mission, Health Mission, that is NRHM, Malad, initially, Malad. Now, thereafter, Malad, it's not a case of regulation also, Malad. It's just the kind of stopgap arrangement. They were appointed temporarily in the year 2017, Malad. Now, this respect, Malad, they cannot claim a matter of right to the promotion. This is not even, they are not regular appointment of there. There's not regular appointment of them. It appears to be a stopgap arrangement. It's temporary matters. Because initial appointment, they
were not regularized.
Malud, from
No,
the
see,
report,
initially they were appointed as laboratory technicians.
Malud,
Then their case is that after working for 9 years,
Malud,
they have been they have been regularized, but regularized not in the post of laboratory technician. They have been regularized in the post of assistant laboratory technician.
Yes, yes.
assistant laboratory technicians, correct?
My lord, my lord.
So their grievances that since they have been working in the post of laboratory technicians and they have not been given laboratory technicians, rather they have been given assistant laboratory.
Laboratory assistant. My lord, and
So now they are saying that like they should be, I mean, they should be this, they should be considered for promotion to this thing because they have already worked in that post.
my lord, in that case, my lord, their initial appointment as a laboratory technician under the NLJ, my lord, it's a society, my lord. Now, the society, my lord, that is where the entire that their salary and the expenditures borne by the government of India, my lord. Now we have no nexus with the budgetary support is no nexus with the state.
But now 2017 they have been regularized.
My lord, they have not been regularized, but it's not a case of even regularized also. As per my lord, see, their appointment is temporarily appointment. It's not a case of regularized, my lord, because for that, my lord, I have to take instruction with the relevant record, my lord.
Where is the order?
My lord, order at page, my lord, see, page 30. Page 79. If we start from my lord, page 76.
76.
76A, my lord, type copy.
'76.
My lord. A. And petition number 2, my lord, is page 82, my lord.
Yeah, I mean, you have been saying that you have been regularized. Where is the regularization order?
Your Honor, but salary given us as per EA.
You are not clear with your facts. You have been is hereby appointed on temporary basis to the post of laboratory assistant against higher vacancy block so and so created so and so. And so you have been again you have been working as temporary basis.
Temporary.
You said you have been regularized. So what is your right? So you want yourself to be regularized or what now? What is your prayer?
Sir, Your Honor, actually for motion,
I mean, you are a temporary worker and you are seeking temporary promotion to where?
same batch, same batch has
No,
been,
without being regularized, how you can ask for promotion?
same batch has been promoted, Your Honor, as laboratory technician.
Maybe on a temporary basis only. Maybe somebody was working, he has more experience, he has been given the post of this thing, laboratory technician. But will that give you a right also?
We have served 18 years continuously as sanction post, Your Honor. Continuously. 18 years is, Your Honor. Say,
These things also not very clear.
My lord, that's right.
Your prayers are also not clear. You list it in the next week. You come prepared properly. You come with the. You factually you are not clear probably. Here it is something else, and you are submitting something else. You said you have been regularized. There is no regularization. Where is the regularization order?
yes, well,
You come prepared. You come prepared. You go through the brief properly, prepare properly. Then you come back. We'll put it on the next week. Okay. Okay.
okay.
Because you see like how you have made out your case, whether you have a case or not. You see, and like we have already pointed out that maybe this Dillon Leches they come in. So you have to come up with your explanation why delay in lectures is not there.
Actually, we serve 18 years, so
See,
statutory recruitment
see,
rules mandate.
Mr. Counsel, you were not fully prepared for this case, and court is giving you an opportunity. You are a young counsel, so you should take this opportunity, go back, properly study the case, and come back fully prepared.
Yes.
Court will consider your case. If you have some grievances, court will definitely going to consider your case. But you come prepared. Because we have already pointed out delay in lecture, because 2017 only you have been, you are saying that your grievances from 2017 only. You said that there are representations have been filed, and those are not considered. Now you have to explain this delay. So you come prepared with those things. On the prayer of, on the prayer of your Mr.
C. Singham.
C. Singham, the learned counsel appearing for the petitioners. Let the matter be fixed on. Fixed on 18th, okay? And if, please take their appearances, take their acquaintance. Then we'll fix it on 18th. Let him come to it.
Matter number 9, passover matter.
May I please your lordship?
Yes.
I'm appearing on behalf of the petitioner in this case, my lord. My lord, in this case, what had happened, the respondent number through respondent number 3 has floated a tender, my lord, wherein for installation of tuber poles for erection of aerial of cables along with accessories on a turnkey basis, my lord, for 3 zones, my lord, wherein the petitioner applied for all the 3 zones under the said tender, my lord. And as L1, he was awarded the tender for only zone B, my lord, herein, and the total cost of that zone B project was 2 crore 63 lakhs, my lord. In this behalf, my lord, as he was selected as a L1, so a letter of intent was also issued to the petitioner, my lord, in this case. And after a letter of intent was accepted by the petitioner, my lord, there was a joint survey which happened with the respondent number 2 and petitioners, my lord. Before the work order could had been issued by the respondent number 2, 3 to 6, my lord, a complaint was filed by one respondent number 7, my lord. Now, first the complaint was filed, second complaint was filed, but thereafter also, my lord, the work order was issued to the petitioner, and necessary materials and other things were purchased. Yes, ma'am.
Complaint was filed before the work order was issued.
Yes, my lord. 2 complaints were filed before the work order was issued. Thereafter, the work order was issued. Thereafter, another complaint was filed. When the third complaint was filed, my lord, regarding the forged document by the petitioner has been placed under the tender, the cognizance of that fact was taken by the respondent number 2 to 6, my lord. Now, what happened, my lord, thereafter, when explanation was called from the petitioner with respect to certain 2 documents, particularly, my lord, one being that experience certificate and the previous work orders, my lord. Now, in this behalf, my lord, once the explanation was sought from the petitioner, my lord, a reply was filed wherein the petitioner explained his position, saying that he has not forged any document, my lord. The experience certificate which he has placed before the government officials, being respondent number 2 to 6, was the certificate which was issued to him by respondent number 7, my lord, in this case. And in 2020, my lord, the respondent number 7 and petitioner worked together in a similar project, my lord. And from there, the respondent number 8 was under obligation to issue the experience certificate in this case, my lord. Now, both 7 and 8 are private parties, my lord, in this case. And 7 has been working for the BSNL, my lord, in this case, being the respondent number 2. And 8 is also working with respondent number 2, my lord. So under such circumstances, the petitioner was given a certificate to that effect that you have participated in this work with us, and the experience certificate was also given, my lord. So that experience certificate was placed before the respondent number 2 and 2 6, my lord. Now, later on, he was also not aware that the document has been forged by respondent number 7, my lord, of the respondent number 8, my lord. Because the petitioner has worked on the project, he applied for the tender and he got the tender based on that fact only, my lord. Now, in the meantime, what had happened, my lord, since the work orders was already issued and the work continued for some time, physical work did not happen. The procurement of the materials happened, my lord, with the vendor. And there was a release report which was issued by the respondent number 2 also from the manufacturer for supply of tuber poles also, my lord. So for 6 months or so, my lord, during pendency of this complaint also, my lord, some part of the purchases were also made, my lord. Importantly, what had happened in this case, my lord, the respondent number 7 withdraw all his complaints with the respondent number 226, my lord. Now, they have already withdrawn their complaints, my lord, and the FIR which was filed against the petitioner was also withdrawn from the police station, my lord. And importantly, my lord, the petitioner acted in bona fide that the certificate which is given to him by respondent number 7 under respondent number 8 is a correct document, your lordship. And importantly to that effect, my lord, when this work was done in 2020, with respect to which the work experience was issued, there is a joint venture agreement and the partnership deed which I have annexed, your lordship. And that is at page number, your lordship, may please to see annexure 17, page 248.
Certificate was given, certificate was, experience certificate was given to you by respondent number 8. And you
Respondent number
said that
7.
you,
Yes, sir.
experience certificate was given by respondent number 7.
Given
He's
under
the employer.
under 8. Yes, your lordship.
What under 8? Under 8 is who?
8 is A to Z infra services. Now,
No, A to Z how A to Z A to Z infrastructure is involved? Because you worked for A to Z infrastructure limited.
no, my lord. I do not work for A to Z infra.
No.
I
Said that, listen. You said that you were working together with respondent number 7.
Yes, my
in
lord.
2020, correct? You
Yes,
were in
ma'am.
a partnership, joint venture, whatever.
Yes.
You worked together.
Yes, ma'am.
Now, certificate was issued by whom?
It was issued by 8. It was given to 7 and it was given to me, my lord.
How 8 has got involved?
My lord, because the seal signature of 8 is there, my lord, on the certificate. Yes, my lord.
Their CA?
Yes, my lord. The certificate was actually issued by 8, my lord.
Certificate can be issued. No, how can the certificate can be issued by 8?
Because
did you work for
originally
him?
the work was between the A to Z and respondent number 2, BSNL, my lord. So they have engaged respondent number 7 to work, and 7 engaged the petitioner also to work together, my lord, in the project. So
Work was given by BSNL to respondent number 8.
8, my lord.
Then 8 has subcontracted to you.
Subcontracted to 7, my lord.
7. Then 7
Yes.
has
7 has engaged me, my lord. He
7
asked
has
me to
roped
work
you
together.
in.
Yes, my lord. So we work together.
He asked you to work together.
Yes,
So the certificate, experience certificate was basically given by respondent number 8.
My
That
lord.
he worked for the project.
My lord.
That was the thing, right? Then
That
what
is
is
the
the
thing.
forgery there? What is the forgery there?
Now, because my lord, this present tender has been awarded to me, my lord, the respondent number 7 came and filed the complaint that the certificate, experience certificate given and submitted by me to the respondent number 2 is a forged document, my lord. Now,
How
I'll
it is
not come.
forged?
They are saying that the respondent number 8 has never issued that certificate.
Okay.
And
Respondent number
importantly,
8
my
has.
lord, and importantly, my lord, the BSNL also inquired back with the respondent number 8 that whether that certificate was issued or not. They stated that they have not issued such certificate, my lord. And because, my lord, the respondent number 7 find himself in difficulty, my lord, he withdrawn the FIR and complaints against me, my lord. Because I was of the view that my certificate is a valid certificate, a bona fide certificate issued by respondent number 8, my lord, to me through 7. Now this respondent number 7 has came forward and he filed a complaint because he knew that the certificate was a forged certificate from day one, my lord. So he is also a competitor to
It,
this to me, my
No,
lord.
it was forced by whom?
It was forged by 7, my lord.
Forced by 7
My lord, given to
and
me.
and given to you.
Yes, my lord. So under such
And
circumstances,
you have submitted the document
I have submitted
as
the document
experience
because I have
experience
yes,
certificate.
yes, my lord. Because I have worked on that project.
Now that has been withdrawn.
It has been withdrawn. Complaints has been withdrawn. FIR has been withdrawn against me, my
Now
lord.
what is the problem now?
The respondent number 2 to 6 are not considering that reply also of mine, my lord. Neither they are considering the withdrawal of the complaint by respondent number 7 also. But they have issued a show cause notice to me, my lord. I replied to that on based on my available facts and everything, my lord. And a termination order has been issued against me, my lord. So the
It's already
tender has
terminated.
been terminated. Yes, my lord. It has been terminated, my lord. That is,
Then no, if it is terminated, what relief you want?
my lord, I am seeking that, my lord, that should be set aside, my lord, because
That should be
that should be set aside. That is my humble prayer, my lord. The termination order.
the termination order is issued. Now it can be set aside just like that.
No, my lord, I'm just humble prayer is there, my lord, that the termination order which is there could had not could had been considered before issuance of termination order, my lord, because ultimately I have already procured the materials. I have the relevant experience also, my lord. If your lordship sees my
And
experience
who is appearing
certificate
for the
also,
respondent?
my lord,
Oh, I'm appearing for respondent 1,
One is who?
learned DSGI.
Hmm?
Learned DSGI for.
Yes. What is your submission? What is your submission to his? What do you have to say on this?
There's no instruction for that.
Hmm?
No instruction for.
You are ASGI or what?
No, I'm appearing on behalf of DSGI.
Where is the ASGI?
Due to some personal issues, she's out of station here.
my lord, in the meantime, the respondent number 2 is preparing to retender this project, my lord. So I have a humble prayer, my lord, my prayer for interim relief that
No
they,
interim relief.
yes, my lord.
No interim relief. Where is your termination order?
My lord, at page 283, my lord.
You don't have any case, Mr. Sanchetti. You have submitted a false document. What is to be done?
No, my lord, that certificate.
I mean that due. I mean, you should have done some homework. You should have.
My lord,
I mean,
for
before submitting it, you should have done it. I mean, it is admitted that that is a false document.
my lord, I'll just draw the attention of your lordship to
See,
one important document. Yes, your lordship.
It has been stated that A to Z infrastructure has stated that they haven't received it. You have relied on respondent number 7. That is your fault.
Yes,
What the government can do on this?
Your Lordship, may I please to see three important documents, Your Lordship.
Yes.
One at page 248, my lord.
$248. Yes.
Yes, my lord. 248 is one is this partnership agreement, my lord.
Hmm.
And
How does it
second, Your
matter
Lordship,
whether Mr.
Your Lordship,
you
because
may have as many as
based-
100 agreements, but you have submitted a false document. That is
no, my
what
lord, I
matters.
have not submitted the document,
you-
whether
the-
that was
the-
forged or not was not within my knowledge, my lord.
Then how,
It is
what
after
government
he
can
has
do
filed a
this?
complaint that I have been awarded
You
with the
should have
tender.
been, you should have been diligent. You should have been diligent.
My lord,
You should have been diligent when you were submitting a document to the government. You, on the basis of that, you have been given the contract, a huge contract. The government is suffering because you don't have experience.
no, I have the experience, my lord, because I have worked
How do you
on
show
that
that?
project,
On
my
the
lord.
papers, how do you show that you have experience? You know that certificate is a mandatory condition of the tender.
My lord, that is
And
there, my lord.
certificate is found to be a false document.
My lord, just a humble prayer, my lord, that if a document has been issued to me, my lord,
Admittedly so, see, while submitting a document before before a government authority showing that you have sufficient experience, you should have been diligent enough to see whether the document has been properly executed or not, properly given or not, properly issued or not. I mean, if you do not see all these things, now later on when it came to the notice of the government has rightly, I mean, it's not that they have simply terminated the contract. They have done some inquiry. They found that it was not issued by the A to Z, respondent number 8. And what government can do?
my lord, in this case, my lord, it's important to just, my lord, may take into consideration one fact, my lord. Who has filed the complaint, my lord? The one who has given the certificate, my lord, to me. Because he is the person who has given the certificate to me. Now when the tender has not been awarded to him, my lord, he went forward and said that 4 years back a certificate which was issued to him was a forged certificate, my lord. It is not a case that I have not worked on that project, my lord. The case is this, that the certificate which was prepared by him was not approved by A to Z, my lord. So that is my humble case, my lord. Once I came to know that this has been there here, my lord, there is one mediation which has also happened, my lord. When it was the work was done, my lord, maybe take into consideration that part also, my lord.
What mediation?
My lord, 252, my lord, page. And I
Yes.
have also filed a complaint, this, my lord, 252 may be taken, my lord, once.
What is this share violation and all these things?
No, my lord, at 252, my lord. And
252
next
is a
is 253.
handwritten note.
No, 253 is a type copy.
That's what I'm saying. What is this share business?
No, this is not share, my lord. At page 253, my lord. Type copy.
Yes, with the utmost regard, I'm saying so. The farm holder FTB Enterprises and so.
It was given in 2021, my lord. And a dispute, the firm that is respond number 7, there was a serious issue about partnership work in between respond number 7 and myself.
You are
and my lord,
you are complaining before a welfare society saying that like equal share was not given to you.
My lord, it was in 2021 when I worked, my lord. I was not given the equal share therein.
Correct. Understand. All these things are there. Do you think like Red Court is going to look into these things?
If your lordship can consider that part,
Whether
because I have already invested around 1 crore.
Wait. Whether you had some partnership with some other person and that your share was not given, that's why you have filed a complaint. Whether those things will be looked into at this stage by this court. Your case is simple that you have submitted a false document. False document means the document forged by someone, maybe your competitor, but you have submitted the document and on inquiry it was found that in fact the document was not issued by the one you have claimed. So that was found to be insufficient, and that's why your contract was terminated. Now, if you have some issues, you go to the law, you go to the, I mean, you go for compensation.
My lord, one last document. I'll not take much time, your lordships. 251, my lord. It's not that the respond number 8 was not aware, my lord, that I am under working for them, my lord, in 2021 itself, my lord. This is the complaint which I
Maybe,
filed with
see,
A to Z also, my lord.
Mr. Sansit, respondent number may be very well aware, but respondent number 8 has not issued the certificate. That is the key. They have not issued the certificate. They denied issuing the certificate. Then, in fact, the issue was that certificate was created by, I mean, allegedly created by respondent number 7, and that you have thought that that is a correct certificate, and you have submitted it without verifying it. And whose fault is this? Now, is this the RIT court is going to look into it? Who has done it? Who has not done it at this stage? If you have any issue, you don't have any grievances against the government. Government has rightly done so. Government has floated the tender. They have given a condition that you have to give a experience certificate. An experience certificate was given by you. Experience certificate was found to be a fake one. Then what government can do at this stage? Are they going to do a lot of inquiry? Who has done this? Who has not done this? Are they supposed to send it to FSL whether they have done it or not? They have found it. They have done a preliminary inquiry. They found it that the certificate was not issued by the signatory. The work finishes. If you have any issues, then you'll have to go to a different forum seeking relief. But in the RIT court cannot do anything.
My lord, only that, my lord, because 7 has done this conspiracy against me, my lord. So I cannot, I am bound by that.
Those conspiracies, whether this RIT court will look into, Mr. Sansiti.
My lord.
RIT court cannot do anything on this. Heard Mr. S. Sanchiti, the learned counsel appearing for the petitioner. Also heard
T. Meto, your lordship, appearing on behalf of DSGI, Mr. M. Kato.
the petitioner's case, and by filing this, the petitioner has challenged the termination notice, termination order dated 13/2/2026. To 2026 issued by the Assistant General Manager in bracket CFA PLZ. BSNL NE-2 Circle, Dimapur, Nagaland. Whereby the work order in respect of Zone B work of tender from Bhalukpong Nechipu /0 in bracket 48.5 kilometer under subdivision Bomdila with route details and the estimated value of the and with the estimated value of rupees 2,63,62,990 was terminated. Full stop. The gist of the fact involved in the instant case is that the respondent number 2, that is that is Bharat Sanchar Nigam Limited, to the respondent number 3, that is the Chief General Manager, comma, Telcom, comma, NE, dash 2 Circle, comma, Dimapur, comma, Nagaland, floated a tender for installation of tubular poles for erection of aerial off cables. Aerial of cable. Is it aerial of cable?
Yes, my lord. Aerial of cables.
Aerial of-
Cable A
aerial of-
oblique ADS.
Oblique ADSS cable testing and commissioning and erection, stroke, slinging of ADSS along with accessories on turnkey basis for 3 zones, that is number 1, zone A being Basar dash Alo in bracket 51 kilometer under subdivision Alo. Then number 2, semicolon number 2, zone B being Balokpong dash Nechipu stroke 0 in bracket 48.5 kilometer under subdivision Bomdila, and 3, zone C being Nechipo stroke 0 point dash Rupa Mode in bracket 38 kilometer under subdivision Bomdila. Full stop. The petitioner was awarded with a work order in respect of zone B of the aforesaid works, with an estimated value of rupees 2 crore 60, that same amount, that crore so and so. And accordingly, a letter of intent was also issued on 01/07/2025 by the respondent number 5, that is Assistant General Manager in bracket BSNL NE dash 2 Circle, Dimapur, Nagaland. To the petitioner, that letter of intent was issued to the petitioner. It is the next paragraph. It is the case of the petitioner that respondent number 7, that is Research FTB Enterprises. He was also one of the tenderer.
My lord, he has not applied for tender, my lord.
He's not applied for tender.
Yes, ma'am.
Okay. Respondent number 7, FTB Enterprises, who is supposedly worked with the petitioner earlier in certain projects, comma, submitted a complaint before respondent number 2 and 3, alleging that the petitioner had submitted false documents in his tender to get the aforesaid work. It is the case of the petitioner that in spite of the aforesaid complaints, the work order was issued to the petitioner, but due to repeated complaints filed by the respondent number 7, the respondent number 2, that is Bharat Sanchar Nigam Limited, called for an explanation from the petitioner, which was duly replied by the petitioner. Full stop. In his reply, the petitioner has stated that respondent number 7 had earlier worked, that the respondent number 7 had earlier worked with him under partnership with investment together in respect of in respect of an work order number A2Z stroke BSNL dash NFS all capital stroke 220 stroke 221 stroke 003 dated 17/12/2020 given by the respondent number 8, that is A2, no, 2 is Roman numerical 2, sorry, A capital numerical 2, A2Z Infrastructure Infra Services Limited. The council, the petitioner's case is that in view of the performance of the work in the aforesaid work order dated 17/12/2020, the respondent number 7 on behalf of the petitioner procured the experience certificate for the aforesaid work from the respondent number 8. Full stop. Accordingly, the petitioner had submitted the aforesaid experience certificate, which was he believed to have been issued by the respondent number 2, respondent number 8 for procurement of the work in the instant case. Full stop. He submitted, he stated that he submitted that aforesaid document bona fide and without any ill intention. Therefore, therefore in his reply, he explained his case and he prayed for consideration, due consideration of the, he prayed for non-consideration of the complaint filed by non-consideration of the complaints filed by the respondent number 7. Full stop. Full stop. Though the petitioner, after replying the so-called notice, the petitioner was expecting a considerable, expecting a favorable, expecting a positive response from the respondent authorities, respondent number 2 and 3, no? Respondent number
Yes,
2
ma'am.
and 3.
Yes,
Respondent
ma'am.
number 2 and 3. However, to his surprise, he received the termination notice order dated 13/2/2026. Full stop. The learned counsel, Mr. S. Sanchetti, you are S. Sanchetti?
Yes, ma'am.
Mr. S. Sanchetti, the learned counsel appearing for the petitioner, submits that the experience certificate which was submitted by the petitioner before the respondent number 2 and 3 for the instant work was given to him by respondent number 7, who worked with him in the same project for respondent number 8. Therefore, he had a bona fide belief that the work experience must have been issued by respondent number 8. Therefore, accordingly, he submitted the experience certificate before the respondent number 2 and 3. He submits that since the work order was issued to him and he has already procured sufficient materials for the purpose of execution of the contract, in the instant case, spending more than
Around 1 crore rupees, madam.
spending around 1 crore, the termination as 1 crore, which is known to the respondent number 2 and 3. 2 and 3 and 6, right?
Yes, my lord.
6 has issued. 2 and 3 and
6 has
2,
issued the
6.
termination.
2, 3 and 6, the termination notice issued by the respondent number 6 is illegal, and the same should be set aside and quashed. Full stop. Full stop. The learned counsel appearing for you are appearing for the respondent number
1, Your Lordship.
Hmm?
1. Respondent number 1.
The learned counsel appearing for respondent number 1, however, submits that there is no illegality in issuance of the termination notice by respondent number 6. This court has heard this. This court has noticed that while issuing the termination notice, interim termination notice, dated 13/2/2026, where is that? Page 70?
Page 283, my lord.
283. to 2026. In the aforesaid termination order, the respondent number 6 has clearly mentioned that the experience certificate issued submitted by the petitioner appeared to be fake and false, and therefore a verification was sought from the respondent number 8, that is Messrs. A to Z Infra Services Limited, who purportedly issued the aforesaid experience certificate. However, the aforesaid respondent number 8 categorically denied issuance of any work order or work experience certificate to Messrs. To the petitioner, full stop. The exact words that have been used in the reply of A2Z Infra Services Limited, that is respondent number 8, to the respondent authorities, is extracted, are extracted here in below. Quotation is right. We have never issued the attached work order to Messrs. Kunjuju Enterprises, nor have we issued any work experience certificate to Messrs. Kunjuju Enterprises from A to Z Infra Services Limited. So, from the aforesaid termination notice, as well as the reply which has been given by the respondent number 8, it is discernible that the petitioner was in fact not issued any work order by the respondent number 8 to issue any work experience certificate. Therefore, the claim of the petitioner that it has worked for respondent number 8 and thereby gained experience, and the same was documented by the respondent number 8, seems to be false and incorrect. Full stop. In view of the aforesaid, finding, in view of the aforesaid finding, now in view of the aforesaid, this court is of the considered opinion that this instant writ petition does not have any merit and liable to be rejected at this stage. Accordingly, the instant writ petition is dismissed. Dismiss the
Highly
motion.
obliged, madam.
Mr. Sancheti, they have denied to giving you work also.
Hello. Actually, my lord, I was,
Yeah,
they must respond number 7 and have done to me, my lord.
may have something that this court cannot look into. But only thing is that they have denied giving you any work also. Forget about the experience. If somebody has given you some work and you, take a certificate from your friend saying that like you give me a certificate that I have worked with him. Not doing this kind of government works. Correct?
Highly obliged.
Matter number 13.
Your Lordship, without making the this issue very long, my lord, I want to present it in very brief way, my lord. I would like to pray.
But I would take long to understand it.
My lord, very easy matter, my lord. I would just pray for this disposal, my lord, because some indication has been given to my client. I have been informed right away, my lord.
What?
Department
He's
has-
considering your case.
my lord, my lord. So
Does he want to withdraw this case?
no, my lord. Actually, I have filed a representation here, my lord. That representation is here, my lord. That's why.
The representation, you want the representation to be disposed of.
My lord, my lord. So, my lord, I would like.
What is your case?
My case, my lord. That's why, my lord. My lord,
You have been working as in-charge assistant project officer you have been working for extension officer for
last 22 years, my lord.
22 years.
My lord, my lord.
Then
And in this page 28, my lord, in page 28, after 18 years, my lord, page 28, my lord.
1 second.
Right.
I have read this, but I forgot it. Yes,
Page 28, my lord.
page 28.
My lord, after 18 years of my service as this extension officer, my lord, I was entrusted with the in charge, my lord, in charge of APO, my lord, assistant project officer, on 29 September 2021, my lord. My lord, I was
So you have been appointed as
APO, next higher level.
appointed as APO higher level than the extension officer.
Yes, one higher level.
Correct. So on 29 September 2021.
My lord.
Then you joined, then you started working, then what happened?
Yes, after that, my lord, permanent vacancy, this occurred, my lord, page 30. Of
Permanent
APO.
vacancy occurred.
My lord, page 30, my lord.
It is not permanent vacancy.
It is, no, my lord.
It is on purely temporary basis.
Temporary basis, my lord. I was in charge, my lord,
But,
so I cannot claim this.
Temporary basis in a grade of extension officer only.
Yes, my lord.
Correct. Then 30,
Page 30 shows, my lord, vacancies arose.
one Sinfo was
He superannuated, my lord.
correct.
My lord. In his place,
So
my lord.
in one vacancy in APO.
My
Correct,
APO,
correct.
and after 22 years, my lord, on this page number 31, in this vacancy, my lord, I was given officiating promotion, my lord. Page number 31. My lord.
Yes.
It is the officiating promotion, my lord. So I joined there in page number 33, my lord, joining report, 4th September 2025, my lord. So,
yes.
Impugn order thereafter, my lord, page number 34, my lord. Whereas I am holding the post.
You are the senior most
Uh,
in the extension officer's grade. Are you the senior most?
not likely, my lord. I have to be very honest, not likely.
No, that
because-
is a very important factor.
My lord, my
Sir.
your lordship. So they have officiated me. They have officiated me by virtue of my efficiency and my long experience. My lord.
Long
Because-
as somebody else may be also having it.
My lord, yes. If that is so, I would,
No, see, like, you do, I mean, now, in the interest of public service, following you under the is transported and posted in the same capacity. Yes, then what is wrong in that?
no, my lord, please see, my lord, please see. Present place of posting, my lord.
Hmm.
As inchers APO tech, inchers. I have been, to ease up the matter, my lord. I am no more this inchers, my lord. I am in officiating. I have been given officiated officiating.
Correct.
appointment there, my
See,
lord.
in charge is like only given for as a temporary basis.
My lord, my lord.
Temporary basis, it can be for different reasons.
My lord.
Okay. So, I mean, in charge giving, but you have been working in the grade of extension officer only.
My lord.
So you have not been promoted. You have been given.
No, no,
only-
after that, I have been given officiating appointment, man.
No, officiating appointment, only officiating appointment.
My lord. No, no, first I was given in charge, my lord.
Mhm.
In charge was there.
Officiating means what?
Officiating means we can say in simple term, my lord, is temporary promotion, my lord.
Not
It is,
temporary.
it is, al-
It's not a temporary. You have been given a charge to officiate it on behalf of somebody because that person is not there. It's like that. Okay. Anyways, you carry on.
my lord. So,
It's only officiating, nothing else.
my lord,
Okay. So officiating doesn't give you any right.
my lord, well, and
So now you have been transferred as EO.
EO, my lord.
Yeah, EO.
E-
So you have been doing officiating work earlier as officiating as APO.
APO, my lord.
APO. So your grievance is that now you have been given the EO.
EO, my lord.
But I mean, now you say that like you should have been given the post of APO.
APO, my
But
lord.
there may be a lot of other candidates who are eligible.
No.
Why they will give you?
My lord, that is an administrative issue. They should then give me 311 opportunity, my lord. That is what my this argument.
See, like, I mean, I don't see any this thing in here, but like if you say that like there is representation they are considering,
Right.
then on that basis, I mean, this can be disposed of.
My lord.
Otherwise, on merit, I don't see any this thing.
My lord,
Prima facie, I do not find anything. Any ground.
my lord, I don't want to lengthen the matter, my lord, since my limited prayer now is this.
So like, that is why I'm asking, if you want that like you have filed a representation,
My lord.
representation is not disposed of,
Yes, my
then that can be directed to be disposed of
Right.
with a reasoned order.
My,
Then if you have any grievance, you can come back. But
Yeah.
at this stage, on merit, if you want to argue, then it will be a different thing. So now choice is yours.
no, my lord, we want this representation will dispose of my.
Okay, heard Mr.
Tijamo, my.
Ujama, the learned counsel appearing for the prisoner. You are appearing?
Yes, ma'am.
You are appearing for whom?
1 to 4, ma'am. Standing counsel RD.
1 to 4, all. Mr. So and so, as a standing counsel, a learned standing counsel. Appears for all the respondents.
Not all, ma'am. 1, 2, and 4.
1, 2, and 4.
Yes.
And for respondent number 2, you are appearing.
3, Your Lordship.
Respondent number 3, junior complainant advocate.
Yes, Your Lordship.
So and so, in the case. The instant writ petition is a petition, instant petition under Article 26 has been filed by the petitioner by assailing the order dated 23rd February 2026 issued by Secretary in the RD Government of Arunachal Pradesh, whereby he has been transferred, whereby the petitioner has been transferred as EO in bracket RE at Hunli Kronli CD block from the post of in charge APO in bracket tech at DD in bracket RD's office at Siang district. Full stop.
My lord, presently, actually, I am holding the post in the office of capacity, my lord. That may be, my lord.
No, here nothing has been shown. I mean, in the impure order, nothing has been
Yeah,
written
yeah,
as official.
Yes, my, that is my submission, my lord.
So and so. The case of the petitioner is that after 17 years of service in the grade of extension officer, the respondent department appointed the petitioner as in charge assistant project officer by in bracket RE, provide order number SNG stroke BRDA stroke ESTT dash 01 stroke 2020 dash 21 dated 27/9/2021 and accordingly he served as in charge APO RE till August 2025. The petitioner was void in order void an order number BRD dash 11015 stroke 9 stroke 2021 dash BRD dash RD dated 1/9/2025. The petitioner was allowed to officiate in the aforesaid substantive in the aforesaid post of APO, right?
My substantive vacancy.
That same post only, APO post only, you have been allowed to officiate.
My lord, my lord.
Officiate. So and so. Pursuant thereto, the petitioner joined as APO in bracket TAC on 4th September 2025, and he has been discharging the functions as Assistant Project Officer TAC. Full stop. The petitioner's case is that all of a sudden, void the impugn order dated 23/2026, the petitioner was downgraded and transferred to the lower grade of extension officer without offering him any opportunity of being heard, in violation of Article 311 of the Constitution of India. Being aggrieved by the aforesaid, the petitioner has filed. Being aggrieved by the aforesaid order, the petitioner has filed the instant writ petition. Full stop. The learned counsel appearing for the petitioner submits that the petitioner was given the the officiating capacity in the post of APO, wherein he has been successfully performing his duties without any blemish. But however, by the aforesaid impugn order dated 23 February 2026, he has been demoted to the post of extension officer, wherein he served more than 22 years. Full stop. He submits that since he was allowed to work in an officiating capacity in the post of APO, which has fallen vacant due to the superannuation of one. What is his name? Superannuation of
My lord, one UN Singapore.
one UN Singapore.
Yes, my lord.
UN Singapore. The petitioner should have been considered. Petitioner should have been considered against the aforesaid vacant post. He submits that rather than considering him in the aforesaid vacancy, aforesaid substantive vacancy, he was unilaterally transferred and he was unilaterally transferred and demoted to the post of EO. Full stop. The learned counsel further submits that in this regard, the petitioner has filed a representation dated 27 February 2026 before the Secretary of Government of Arunachal Pradesh, Department of Rural Development, stating his grievances and with a prayer to consider his case, consider his case full stop. However, in spite of the receipt of the aforesaid representation, the authorities, the government authorities are yet to respond to the aforesaid representation. In view of the aforesaid, he submits that he submits and prays that his representation, he prays before this court that a direction should be issued to the respondent, to the secretary, to the government of Arunachal Pradesh, the Department of Rural Development. That is respondent number
1 and 2, madam.
respondent number 1. Respondent number 1 to consider his representation and dispose of the same. This court,
My submission may be recorded.
what is your submission?
His substantive post is EOR, madam.
He is only asking for
Yes, yes.
I mean, if the court would have entered into the marriage,
Yes.
then it would have been different thing.
Yes.
But now since they only the disposal, he
Yes, yes.
dispose it, I mean, whatever is
Yes, yes.
this court on this court after hearing the submission of the respective counsel appearing for respective parties, as well is also is of the opinion that at this stage, since the petitioner has submitted a representation explaining his grievances before the respondent number 1, the same could be responded by, same can be responded by the same can be considered by the respondent number 1, full stop. Accordingly, it is directed that respondent number 1 shall consider the representation dated 27/2/2026 submitted by the petitioner before him within a period of
2 months, my lord.
within a period of 2 months.
My lord, at least then, my lord, some protection may be given, my lord, I may not be released then.
No protection.
My lord, your lordship,
No protection. Okay, well, I mean, you dispose it in 1 month. Why?
My lord,
so-
this March is coming, my lord. March, my lord. So they will be busy one.
That, 45 days. Okay.
Right. From the date of
Dispose
receipt certificate.
Dispose of the represent so and so within a period of 45 days from the date of passing of this order. You are there.
Of the city.
You give it tomorrow. Copy. You intimate them. Why you need? Those days are gone, Mr. Counsel. Certified copy. You wait for 1 week, 10 days. Those days are gone. Now you get the order. I mean, if you don't get it today, tomorrow you'll get it. From the passing of the order. Okay. Passing of the order. Full stop. However, a certified copy of the instant order shall be submitted by submitted before the respondent number 1 by the petitioner at the earliest. Full stop.
your lordship, in fact, in my submission paragraph number 13 also, I am not agitating against the transfer, my lord. In my paragraph 13,
Yeah, you are easily officiating. Let them consider it. I mean, but you don't have any case. I'm telling you. I mean, like I'm not. Going into the merit of the case, but prima facie, I'm saying. But let them consider. I mean, they may consider because there is a vacancy now. Correct. There is a vacancy. They may consider. I mean, if you are the most eligible person, most senior most person, they may consider it. So, in view of the opposite direction, the instant repetition is disposed of.
Item number 14.
Right, please, Lordship. But in this representation, basically, I'm raising 2 issues. One is in 13/12/1977, the preliminary notification under Section 5 of the Assam
Forest Reserve Regulation in 1891 was published. And in August 1978, the proclamation under Section 6 was published. But thereafter, nothing has been done so far for a proposed Delhi Reserve Forest model. Now, only in 1995, the Deputy Commissioner has directed the ESC, Hyuliang then, for conduct of the public meeting. And in the public meeting, it was clearly rejected. And that rejection order, the rejection information was submitted by the ESC also. But so far, no proceedings from Section 7 to 17 has been done. No final notification. Now, therefore, my lord, we have written our presentation. DC has on 2 occasions has.
No, you are who? You are who?
I'm one of the landowners in that area of the villages, my lord.
You are one of the landowner in a village where this reserve forest is there?
Yes.
Reserve forest is there.
Not the reserve forest, it is proposed reserve forest, my lord.
Okay.
Within that
So
area, our villages,
So now you have been, I mean, you have been evicted over.
not yet not evicted.
Hmm.
Now, my lord, now the frontier highways is being constructed. Now that is passing through that area.
That area.
And that is my second aspect. Now the Deputy Commissioner has come to a conclusion that since it is a proposed reserve forest, therefore there is no question of payment
Land
of
acquisition there.
no land acquisition is required.
No land acquisition required because that is a reserve forest.
Proposed reserve forest.
Proposed reserve.
Yes,
forest.
my lord.
Proposed.
Now my responsible submission is that proposed reserve forest is not a reserve forest until and unless the legal requirement as per this thing reservation
Hmm.
regulation.
Hmm.
So this is Delhi Reserve, proposed Delhi Reserve Forest is not a reserve forest, and therefore my first prayer is for seeking direction to the state respondent to annul that earlier notification as proposed by the land settlement officer on 2 occasions, my lord. Now, secondly, since the frontier construction is going on, my lord, I am in any case I am entitled for the compensation. Now, my lord, just for argument's sake, my lord, even if it is a reserve forest, although this is proposed reserve forest, it's not a reserve forest. Even if it is reserve forest, my lord, under this Forest Settlement Act, the tribals, we belong to the Mishmi tribes. So we are entitled to get compensation to the maximum of 4 hectares per person, my lord. So in any way, my lord, that I'm not harping on it, but my lord, at this stage, my responsible submission is that while issuing notice, my lord, since we are not opposed to the construction of the frontier road, my lord, that will be beneficial for all of us. Now, my lord, in the meantime, supposing if everything is uprooted, then tomorrow if we come to the situation that your lordship will pass an order that
Is there a notice issued to you?
no,
Nothing.
nothing.
So we'll just issue notice at this stage.
Only one, only one slight observation is an interim observation, my lord. So if your lordship can come to page 27 of my writ petitions, your lordship may kindly consider this, because once that road is developed, constructed, the properties will be damaged. So
Then what is the stage of the road now?
now it has not yet been constructed, but process has already started and it has not reached our area, my lord.
It will take some time. I mean, I think this matter can be heard, then suitable order can be passed.
Yes,
At this stage, we'll issue notice. Heard
Well,
this.
my lord, just
heard
an
Mr. T.
observation that pendency of this petition shall not be a bar if the responsible authorities look into our grievances as,
That can be done.
yes.
That can be done. I mean, if they have some grievances, they can file a representation. You can look into it.
Okay, definitely, my lord. Now what?
They are your people only.
My lord, my people on, my lord. Now, what the others have indicated, my lord, is basically, my lord, basically they want a land compensation, my lord. Because Trans Highway is going on. We'll
Not
be
only
passing
that.
through that. Now,
See, that is obviously, I mean, everybody
That is
faces
the
that.
ultimate.
I mean, if you are taking his land, then you'll have to pay compensation.
Yes.
Obviously, for that, they have to prove the ownership of the land, so many things are there.
Yes, this issue notice.
Those is the-
Heard Mr. P.
can be done.
Patil, the learned counsel appearing for the petitioners. Also heard Mr. Sorensen, the learned additional advocate general. For all the respondents,
No, my lord, I'll be
for respondent
1 to
number,
5, my lord.
for respondent number
1 to 5, my lord.
1 to 5,
1 to 5.
1 to 5. Anybody, government, you are, Mr.
6 and
So-and-so
7.
appears for respondent number 6. 7, nobody is appearing, no?
7, yes.
Standing, but he's not there, okay. So-and-so. This instant application, the instant petition is filed by the petitioners.
My lord, since the question is pertaining to my reserve forest, when you say reserve forest, my property belongs to the Union of India. Now, when you say reserve forest, there is Ministry of Forest, Climatic and Environment. My lord. They are not made party. My lord.
No, I mean, they have made the Union of India, let Union of India come.
No, Union of India is
Forest Department is the respondent number 4 and 5.
No, reserve forest. If it is a reserve forest, central
Reserve forest. Proposed reserve forest is not a reserve forest.
That is their contention.
Yes, and until and unless it
If
is.
required in the order next date, I mean, that they will do it, if
Yes.
required.
Uh,
See, we'll see.
That is
But
why,
at this stage, at least, that, I mean,
Right, my lord. At this stage, even I will not harp for delay, my lord. Forget it.
at this.
1977 notifications.
We are not challenging the 1977 notification per se. We are saying that this has not culminated into a reserve under section 17. So therefore, this has to be annulled, as has already been done by the government in other
Annulled means
case.
what? You are asking for cancellation.
Why are you objecting against this? You have not carried out your obligation.
No, you said that
You
are asking for
ought to have
annulled.
declared, you ought to have taken up the steps from section 7 to 16 and then.
Mr. Patil, see, I mean, fun is not only outside, fun should be inside also. You know what he is doing.
The moment you say my annulment, that's the amount of cancellation of it.
Application has been filed, so. With the grievance that the petitioners are inhabitants in the area
So various villages falling within the proposed Delhi Reserve Forest.
the petitioners belong to the Missimi community, and they are inhabitants of various villages in the proposed, which is that
Delhi, DELAI, Delhi Reserve Forest.
Delhi Reserve, the proposed reserve forest. Proposed reserve forest. The forest. Reserve forest, full stop. In 2025, the respondents, which respondents?
Respondent number 3, Malad.
The respondent number 3. Is it respondent 3?
Yes, Malad.
Respondent number 3 issued.
No.
104, Malad, page 104, Malad. Malad, this is where I'm slightly harping on an interim.
Deputy Commissioner, correct?
Yes.
No,
Deputy
sir,
Commissioner is the land settlement officer, man.
The issued by respondent number 3. The respondent number? Yes, three, respondent number three. Respondent number three, dated 4/7/2025, declaring the land.
Last line, my lord.
One second, declaring the land falling within kilometer 60.000 to 121.5000 of the frontier highway passing through Delhi proposed reserve forest. Therefore, no acquisition of land is required. Full stop. Full stop. The petitioners are aggrieved by the aforesaid notice because the Delhi proposed because the Delhi proposed reserve forest is yet to be declared a reserve forest under the Assam Forest Regulation, 1891. Is it still existing?
Yes, my lord.
1891. And therefore, if any land acquisition is required to be done for the proposed, what was the project proposed?
My lord, instead of that, my lord, the deputy commissioner has on 2 occasions.
No. What is that project?
Right.
Huh?
Arunachal Frontier Highway. My lord. Arunachal Frontier Highway.
Arunachal Frontier Highway.
Yes, my lord.
Arunachal Frontier Highway.
My lord, this
What is
touches.
the line in the last line highway? Correct. Proposed Arunachal Pradesh Frontier Highway, Frontier Highway, that has to be done as per the law laid down under the Land Acquisition Act. Full stop. Full stop. The petitioners grievance is that by issuing the aforesaid notice, the rights of the petitioners are tried to be taken away from any compensation. Full stop. Full stop. The learned Mr. T. Patil, the learned counsel appearing for the petitioners, submit that that the petitioners are inhabitants of that area whereby that aforesaid Arunachal Pradesh frontier highway will cross and in construction of the aforesaid road, there are high probabilities that the land belong to the petitioners would be
And other land on.
would be used or utilized, and therefore, since the land belongs to them, he submits without properly acquiring the land, the the responding authorities should not utilize their land. He submits that by the impugned notice, it has been stated by the deputy commissioner that since the area falls under Delhi proposed reserve forest, no land acquisition required to be done, which is not correct as per law, as that Delhi proposed reserve forest is yet to be made a reserve forest, and therefore any acquisition that is required to be done by the government has to be done as per the Land Acquisition Act, or prevailing Land Acquisition Act. Full stop. Next para, the learned additional government advocate, however, submits that the petitioners have indirectly challenging the
Preliminary notification.
challenging the Delhi proposed reserve forest notification issued way back in 1977. Therefore, 1977, full stop. He submits that the proclamation is not issued as yet, right?
No, but proclamation on the section 6 was done.
6 was done.
Thereafter, actual claims and
Final
objections.
notification was not given.
Section 5 is preliminary notification.
Hmm.
Section 6 is proclamation. Then it stopped. Nothing has been done.
Then after 17 notice was not given. Final notice.
No claims and objections from section 7 onwards, and no final notification under section 17.
So like there's a factual, I think, correct?
Well,
thing?
Yes, that is.
Claims and objection was done, my lord, as per their records. Admittedly, well, after that, there is no any development, my lord, like final notification.
The learned additional government additional advocates general fairly submitted that though the process of issuing of notification of Delhi reserve, Delhi proposed reserve forest is on, the same is yet to be issued. Full stop. If issued, the full stop. Taking into consideration the submissions made by the learned council appearing for the respective parties, let the notice be issued in the instant, and also taking into also keeping in mind of the fact that the issue will require some consideration. Let the notice be issued on respondents returnable within 4 weeks. Returnable within 4 weeks. Right? Notice to respondent number.
Accepting on behalf of 6 and 7.
No.
On 6.
Additional number, yeah.
I'll be appearing for 1 to 5.
1 to 1.
1, 2, 3, 4, and 5.
1, 2, 3, 4, and 5. Since learned additional advocate general has put in his appearance for respondent number 1 to 5, formal notice is dispensed with. Notice to respondent number 6 is also dispensed with as Mr. So-and-so appears on behalf of respondent number 6.
I'll take steps on 7.
Notice. However, extra copies, requisite number of extra copies of this petition to be served on the respondent numbers 1 to 5, as well as respondent number 6. Full stop. Notice to be issued to respondent number 7 by speed post as well as usual course within a period of 5 days of passing of this order. Full stop. Let the matter be listed after 4 weeks.
My lord, we don't want to put any hindrance to the construction of the road. Nevertheless, my lord, once that is bulldoze and all these destructions goes, supposing tomorrow.
You immediately come to the court and mention it. Court will consider it. Because now nothing has started. I mean,
already construction is already started.
But you are not affected, is it?
Not yet.
It will be, we will be immediately within this 2-3 weeks time that will reach. Because we don't want to put an any.
Then you'll have to file an IA and like, bring this on record. Because I mean, now you are not being evicted and like your land is not being, troubled by them as yet. But so at this stage, I mean, any order,
will be, because the full-fledged, because this is a prime, considering that boundary, that issue.
But you'll have to
This
come,
frontier railway.
you'll have to mention it in like, bring it to the board.
Otherwise, an observation that interim order shall be considered the next.
Might not be, my lord. One side they are saying, my lord, they are not objecting to development activities. Another says, my lord.
My basis of submission is, I don't want to be a hindrance to the construction. Nevertheless, if my property is damaged.
I mean, that line, I think that will not harm you.
Yes.
I mean, only thing is that, I mean, you can write,
My lord,
any,
my lord, why I'm saying, because if it is, my lord, for presumed to be a reserve forest also, any property damage,
they are entered the for.
Correct. No, see, I mean.
That assessment will be required.
Otherwise also, if he, if he, finds any threat, then obviously he'll come to the court for an interim order, right? And otherwise also, if I write it here, there is no harm.
No harm, my lord.
Otherwise also,
My lord,
you can write that if any interim order, if required, that would be considered, on the next day. Then we let him, if he gets something, then otherwise, if he is not affected, then there is no requirement of
Yeah.
interim order.
Obliged.
Matter number 15.
So, my lord, petitioner hearing is presently serving as the assistant engineer in PW, my lord. Substantive post to assistant engineer, my lord. But he is agreed by the improved transport order decree, my lord, 59/2025, my lord. The basic ground is, my lord, within a year, my lord, I have been subjected to 4 times, my lord, transfer, my lord, within a year, my lord. So, my lord, there is a policy guidelines which stipulates that, my lord, the minimum normal tenure, my lord, in a posting of place, it should be, my lord, normally 2 years, my lord. But in my case, my lord, may I take to improve order, my lord.
What is the transfer policy guideline?
My lord will find is number 32. Is the, my lord, some modification by this order, whereby, my lord, earlier the tenure was 3 years, subsequently modified to 2 years. My lord.
But it's not that government cannot do it within 2 years also.
My lord.
In exigencies of survey, there are many reasons. There are many reasons. But where is your, what are your, these things?
My ground, my lord. Thereafter, my lord.
You show me those 5, these things.
Thereafter, my lord, first, my lord, this 4 transfer order, my lord will find.
First one is 9 September.
No, my lord, first, my lord will find at page number 20 onwards, my lord.
What is 19?
19, my lord, 19 is the, this thing, impugn order, my lord.
19 is the last one.
Yes, my lord.
Why have you come so late?
My lord, as on today, my lord, no reliever. I have not been released, my lord.
No, whatever, I mean, like, whatever, it was passed in 2025.
35.
And you are coming now to challenge the transfer order.
My lord,
You go and join.
my lord, as on today, my lord, no reliever, and I have, my representation is still pending also, my lord. I have immediately filed a representation, my lord. And my lord, the reason being I have given, my lord, because this is something, my lord, within a year, my lord. 4 times, my lord. And very interesting, my lord.
See, the 9 September 2025, then the second one.
My lord, this is the impugn order, my lord. The first transfer order, my lord, will find at page number 20. It starts from page number 20.
15th October.
Yes, my lord. It's 15 October.
So you have been transferred from Bameng PW subdivision to
AE Balijan subdivision.
Have you joined?
Here, this was, my lord, subsequently, this was modified, my lord. My lord will find page number 22.
Then Bameng subdivision is under order transfer to Balijan.
So thereafter ASW SEPA, there I joined, my lord.
So ASW SEPA is the only order of transfer. Then
first from there, then, my lord, from there, ASW SEPA, my lord, will see the date, my lord, 15 January. Thereafter, immediately within 5 months, my lord, from ASW SEPA to Tipu subdivision.
Where is that?
My lord will find page number 23.
I know is SEPA. Even the Tipu subdivision. Okay, have you joined there?
Yes, my lord. This is the place, my lord, where right now, presently, my lord, from where I have been sought to be transferred by this impugn order. And as on today, I have not been released, my lord. I am still functioning from there, my lord. Now, well, very interesting, my lord. My lord, this I have sought for RTI reply, RTI documents, my lord, seeking the, my lord, proposal, grounds, reason, my lord. And very interesting, my lord, reply letter given, my lord, there is no proposal, no reason, and even, my lord, approval of the competent authority is not there, my lord. This RTI reply, my lord, I have received, my lord. Kindly, my lord, turn to page number 25, my lord.
25 or 24?
25, my lord. Annexure 4, RTI reply. My lord, then file my representation on 23/9/2025 itself, my lord. This is
Where?
page number 24, my lord.
20?
2424, annex 3, my lord.
24.
Yes, my lord. This is my representation. Immediately, my lord. Sign on 23/9/2025. It was submitted on 23/9/2025, my lord, at the bottom. Receipt, yeah, acknowledgements also there, my lord. Once is saying, my lord, within a year, my lord, four-time transfer, my lord.
Okay.
This is now, my lord, this is the case from the record event, my lord, saying, my lord, no reason, nothing, my lord. So many issues are there. My lord. Now, my lord, as so far principle, my lord, settled proposition of law, so far the transfer and posting, my lord. Of course, no matter is no more rest in the my lord. Well, here is the case that basically when the frequent transfer is given, my lord, then definitely, my lord, some specific and special cause and reason has to be there.
Okay, well, let us hear him. Yes, Mr.
My lord, I'm sorry, my lord. My lord, you all know, my lord, transfer and posting, my lord, is the exigency of service, my lord. Now, if your lordship rightly pointed out, my lord, now petitioner, if your lordship after 6 months or after 5 months, my lord, the impugn order was issued on 15 September 2025, my lord. Now we're in March 2026, my lord. So 6 months. So 6 months, my lord, as per his person, my lord, he has not been relieved. We don't know, my lord, how far that's true, my lord. Now, my lord, coming to my lord, as you are saying, my lord, proposition of law, my lord. When you say, see, my lord, the Union of versus SL Abbas, that 1993, the Supreme Court had clearly said, my lord, on what ground the Red Court can interfere. 2 grounds has been cited, my lord. Number 1, my lord, mala fide. Number 2, my lord, there is a violation of statutory provision, my lord. And here, my lord, I don't see any 2 of the reasons cited by the Supreme Court, my lord. And in that case, Supreme Court also said, my lord, it is the employer, my lord, as your lordship ever, my lord. Now the transport posting, this, my lord, all comes, my lord, within the, my lord, arena of executive decision, my lord. Now, in the decision making, is there any mala fide or not? That your lordship to see. My lord, while carrying that mala power, is there any violation of statutory provision or not? Now, when you see, my lord, this syndicate case, my lord, even SL Abbas also said, the authority or, my lord, the statutory power of transparent posting guideline issued by the executive. They says, my lord, it's a mere guidelines, my lord. It does not have that authority like a statutory type, my lord. So in syndicate also, my lord, even there is slight violation of the guidelines prescribed by the state government. Even that, my lord, the transfer and posting which has been issued in public interest cannot be come into illegal. Now, here's the case, my lord.
But in your transfer orders, I mean, nothing has been written.
My lord, transfer order, my lord, ground will be not there, my lord. But
No, I mean, you don't mention anything.
my lord, mention, my lord, against existing vacancy, my lord. The lordship may kindly see the posted to the extreme right, my lord. If your lordship see, my lord, the page 19, my lord, the petitioner number is serial number 3, my lord. Hanu Mangfi, my lord, Ipu subdivision. He has been transferred to Pizarang subdivision against existing vacancy, my lord.
But
Now-
are you saying that like, I mean, only because that you have the power and you are the policy maker, you will
Or-
transfer a person, 3-4 times.
May I just put it like this, my lord? Maybe Mr. Soner is very expert in the technical end. Since this is a existing vacancy, maybe my lord, his expertise is required in the subdivision, my lord.
No,
That could be, that will be the public,
no,
greater public interest, my
That would
lord.
have been very nice.
My lord.
That would have been very nice,
Like-
but that is not the reason. There is no reason given.
My lord, even I'm shocked to see,
In the
my lord, RTR,
in the RTI reply, there is no gift.
uh,
There is no record they are saying.
my lord, that is, my lord, unbelievable, my lord. Even, my lord, e-file
No,
proceeding, my lord.
Are you disputing this?
My lord, my
Are
lord,
you disputing this RTI reply that has been done by the PIO come Undersecretary PWD?
my lord, right now, my lord, I am not disputing. What I am saying, my lord, now as per this RTA or as per the submission made by the Learned Council, even there is no approval from the competent authority. My lord, that was the submission made by the other side. My lord. That cannot be, my lord. Either the file will be moved in e-file or hard copy, my lord. There must be some
it
sort of
says
document, my
The
lord.
recommendation approval along with recorded reasons is not available in concerned file. Then it says the reasons in the manner, in the matter are not
My lord.
available due to non-availability of relevant records.
My lord, I have gone through the reply. My lord, that RTA reply, my lord, even I'm shocked, my lord.
You get,
My lord,
no, you
we can
get
get-
instructions.
My
on
lord, can you
Monday.
do something, my lord?
You get instructions on
Yes, my lord. Can this matter be listed on Monday or Tuesday, my lord? Let me get the instruction. my
Monday. You
lord.
get the
Yeah.
instructions.
Monday, my lord. Yes, my lord. We can try on Monday, my
But
lord.
Tuesday, because it's a Tuesday, it will be a division bench.
Division.
Yeah, Tuesday, I mean Tuesdays and Thursdays, it will be division.
Very well. Monday, my lord.
Other days,
My lord.
or you can get it in Wednesday.
Wednesday, my.
Wednesday. Okay. Wednesday.
My lord, even I'm shocked, my lord, by going to this RTA reply. My lord, it is not possible, my lord.
That's why I'm also saying.
My lord.
I'm also saying. Heard
In the
Mr.
meantime, I may be brought.
No, that this is not. He's getting on Wednesday. Nothing will happen. You have not been released for, and you have come to the court when?
After 5 months, my lord.
After 5 months.
5 months after.
And then now you want a protection. Heard Mr.
Asana.
Sonan, the Learned Counsel. Rajesh Sonan, right?
My lord.
Sonan, the Learned Counsel appearing for the petitioner. Also heard Mr. I just forgot your name.
RH Nabum.
RS where the Learned Additional Advocate General for
All are the official respondents, my lord.
Hmm?
All are official respondents, my lord.
All,
my lord. There is no reliever, my lord.
okay.
Mr. Soner.
No
For the respondents, full stop. Full stop. The instant petition has been filed the same. Therefore, the petition has been filed by the petitioner with a grievance that within a period of 1 year, he has been transferred to different places. How many times?
4 times. And the last order was within 3 months, my lord.
My lord, sorry, not 4 times. It should be 3 times because
3 times.
one part was not acted
One
upon,
was-
my lord.
I did not.
For 3 times, for three times, full stop. It is also 3 times against the government policy. Against the government guideline where?
My lord will find a,
Page 32, if I correctly remember, that was 30.
I mean, case 32, my lord.
Against the government guidelines. The government guidelines dated against the government order dated 19/12/2008 full stop. The Learned Counsel appearing for the petitioner submits that the petitioner has been transferred from place to place without giving any reasons for his transfer, and accordingly in an RTI application that he had filed before the authority, he received a reply that there is no mention about any ground of his transfer from one place to another in a within this short span of time. The Learned Additional Advocate, on the other hand, Learned Additional Advocate General submits that the transfer is a policy of the government and on exigencies of service and administration, the person can be transferred from one place to another. However, the same definitely has to be backed by some reason. Full stop. Therefore, may you write, stop that. In view of the opposite submission, this court has directed the learned additional Advocate General to get proper instructions from the concerned authorities about the reasons of this reasons of frequent transfer of the petitioner. The learned, accordingly, let the matter be fixed on
11th,
11th, let the matter be fixed on 11th, right, like this. Understand?
On that day, my lord, my prayer in dream,
That will be, I mean, that will be there, that always you can raise.
but that may be recorded. my lord.
Not required, no. That you, I mean, you will be definitely pressing it, the court knows about this.
Probably, madam, on 11th, everything
And
will be
once you
settled,
press
madam.
it, then court has to either consider or reject it. And if it is rejected, then has to be some reasons.
Madam.
So don't worry about that.
Obliged, madam.